may it come up on Wednesday?
No, it can come up only on Friday, Thursday. Next week, Thursday.
Yeah, next week, Thursday, fine.
All right. Item
13, 1-3, my lord.
Item 13, list this matter on Thursday as per next Thursday. Next week. Yes.
Item number 24. Senior Bharadali sick. Kindly 17.
Item 24.
Arjan.
All right. List this matter next week as per.
17 of the year 2005. Maybe added to the list, my lord.
The second of all, the year
Go to one matter. One
matter, my lord.
One man.
second of all, year 2017 election.
देखिए. Any other?
Document list item number 1, election petition.
Last time notice was issued today for appearance of the.
Who's appearing? You're appearing.
I'm for the.
We are filing for the respondent, my lord, or Bhakarama, along with the memo of appearance of
Yes.
my senior,
You are Mr. Biswa.
T.K. Vishwa.
T.K.
Aye.
Yes.
And another I is filed for time, 2 months time. Because
2 weeks हो चुकी नहीं तो.
ये छुट्टी पड़ी जरूरत ना.
Sri Sashikanta Mishra, advocate and associates have entered appearance for the respondent by filing Vakalatnama in the court. Memo of appearance of learned senior counsel Sri Bidadhar Mishra is also filed in the court. The same be kept on record. An IE is filed in the court seeking 2 months time to file written statement.
Copies are my lord.
The same be registered. Copy of the petition is served on learned counsel for the petitioner. It is time for filing of the written statement is sought on the ground that because of the ensuing assembly session, the respondent has not been able to impart necessary instructions to his to the council for preparation of the written statement. Accordingly, 2 months time is requested to be granted. Yes, what is your view in this? After occasion. Learned counsel for the petitioner has no serious objection to the prayer for time being allowed. However, considering the nature of the dispute, this court grants 2 weeks time to the petitioner, to the respondent to file a statement. List this matter 2 weeks per hour. 3rd October.
My lord, तारिणी ने तोरणी TARANI.
नहीं से लिखा लाड़ू इसे भूले जी.
Item number 2.
Sorry for that. तोरणी है TARANI. Yes, item 2.
Lordship, I'm appearing on behalf of the petitioner.
Yes.
Your Lordship, the election petition has been filed to challenge the election of the returned candidate, Mr. Anil Kumar, from 133 Barampur Assembly Constituency, on the grounds of his nomination paper having been improperly and illegally accepted by the returning officer.
How so?
Your Lordship, the prescribed form 26, that is to be filed along with the nomination paper by all the candidates, that is a false affidavit. The returned candidate has misled the electors and the voters by filing false declaration, giving incomplete information. Your Lordship, if you may come to page 13 of the petition. Column 7A of form 26 asks for details of movable assets of the candidate, which includes details of the bank accounts, the date of deposit, the amount of deposit, the branch details, etc. This particular candidate has not, while he has given the bank account number and the amount in those said bank accounts. He has not given the other details that are required to be furnished, like the date of deposit, the name of the branch of the said bank in which the said deposit is made. And so also the candidate has not disclosed about his election expenditure account in this said column of 7A2. Further, Your Lordship, the return candidate is also required to file
All these incongruities or shortcomings, can they invalidate his election?
Yes, Your Lordship. Your Lordship, under Section 33 of the Representation of People Act, the voters have a right to information. So
He has given information.
he has given information, but these information are not complete. The idea of Form 26, it's a very detailed form which requires details of investments, of movable assets, of the jewelry that he has, the immovable assets that he owns, his educational qualifications, so on and so forth. Any deficiency in that said form or any incongruity to give that particular information leads to the voters having incomplete information about the candidate. So while the voters have elected him, they have elected him without having the said information.
And who are you? You are a candidate.
No, Your Lordship, I'm an elector.
You're an elector. Okay.
Yes, Your Lordship.
Okay. What's your good name?
Natasha Agarwal, Your Lordship.
Heard Miss Natasha Agarwal. Admit, issue summons to the respondent by both ways, fixing 4 weeks for filing of written statement and settlement of issues. Lest this matter to be a vacation on 7th November.
Okay, Your Lordship.
Requisites be filed. Requisites already filed. Yes. Yes.
Item number 3, registrar Mishra.
That to take instruction. Petition is seeking remuneration and allowed to work.
Yes.
Is seeking transfer.
No, she was not allowed to join apparently because of her caste. This is a very serious matter.
Yes.
If this is true, then it is very serious. That is why I wanted you to take instructions.
Next week.
As requested by Land State Council, is this matter next week? The previous order be complied with positively.
Item number 4. Item number 4, may I please, my lords. Lords, I have filed this application for transfer of the criminal proceeding under section 125 filed by the wife, my lord, from the court of Landed Family Court Bhadrak to Jajpur, my lord. My lord, in the meantime, my lord, the wife has also preferred a transfer application, and this honorable court has passed an order admitting the so my lord, may I
Transfer application from? For transfer of which?
to the civil proceeding, my lord, which I have filed in the year 2023, my lord. And this application has,
Transfer it to, it is pending in which court?
it is pending before the court of Landed Judge Bhadrak, my lord. My lord,
So
the
she wants it to be transferred from Bhadrak to Jajpur.
No, my lord, I want to transfer it from Bhadrak to Jajpur, and she wants to transfer it from Jajpur to Bhadrak, my lord. So this matter is arising out of a matrimonial discord, my lord, that can be settled, my lord. So lordship may just
Where is that matter posted to?
just furnishing the copy of the other order. My lord. So this matter may be tagged up and
No date has been fixed.
no date has been fixed. So lordship may just fix any date and this matter may be tagged up and.
Place this matter tomorrow along with TRPC number 146 of 2024.
Grateful, man.
Item number 5,
May I please ask? That the petitioner being wife file seeking transfer of the CP case number 279 of 2024 from the Court of the Learned Judge Family Court Bhubaneswar to the Learned Judge Family Court Jagatsinghpur.
On what ground?
Ground of financial constraint and distance.
Call it notice, stay. Date karo.
7th November.
7th November.
Item number 6,
May I please? I am for the wife, my lord.
Yes.
I have filed this application for transfer from Jajpur to Khurda, my lord. I am the housewife.
Take notice. Notice, stay, 7th November.
Obliged.
item number 7,
Item 7, may I please, your lordship? Your lordship, as per the direction given by your lordship, I have got the instruction that the petitioner has given the representation through post, your lordship. On 16/8/2023, she has given by post to BTO and sub-collector and CPO, your lordship. Postal report, your lordship, as per your direction, your lordship.
खाली तीनटा आपण रिसीट देले.
Lordship, I have already annexed those
तर मग तो खोजी की ताकू जोडिया पडियो ता संग.
Slides.
से तो आपण कहलो. That is what you want me to, you want the court to do. एटा ताकू रिलेट करछु बोले केम जानिबा आगे.
That's the only instruction I got from the petitioner, your lordship, that on.
When was the representation by your father given? When have you stated that?
Your lordship, it's annex 11, page 45, your lordship.
ଆମେ 10 ଦରଖାସ୍ତ କରି ପିତବାସ ମଲେ କିତେ ଦିତେ 11/8 ଆପଣଙ୍କ କାର୍ଯ୍ୟ ଉପସ୍ଥିତ ନିବେଦନ କରୁଛୁ. ଏଟା 11/8 ଦିନ.
Your lordship.
This is of 16/8.
Letter on given by me, it is on like page 46, annex 12, your lordship. So the representation which was given by my father, it was not considered. Later on again, representation was given by me on 16/8/2023 with the medical certificate, your lordship.
Give a copy. Give a copy to the State Council and we'll you take instructions. The only point that, if I remember correctly,
Yes.
yesterday, she has a outside chance of this court interfering only if she can prove that her father had given something in writing, which was never considered. If it has been given by registered post, then at least that can be considered.
Ought to have reached.
Yes, but it may have reached after the selection process is over. But then, if it is her allegation that physically when her father went to give those give the representation, it was never accepted. That is why he was constrained to send it by registered post. Yesterday, she could not show, she could not
Yes,
say
okay.
whether there was any.
Communication.
Just very weak case. Let us see.
I would request my friend for an extra copy because
No, I'm giving extra copy of the.
extra copy of the read petition.
All right. Learned counsel for the petitioner files copies of the postal receipts of the letters containing the representation along with medical certificate submitted at the relevant time before the authorities, sent to the authorities at the relevant time. Let a copy of the memo, let the copy of these receipts be also handed
That
over
has
to the
been
State
given.
Council. An extra copy of the writ application be also served upon him. The State Council shall obtain instructions with regard to the assertion of the petitioner that time was sought for on the ground of her illness at the time of selection by her father, but the same was never considered. Yes, list this matter 2 weeks prior on 3rd October.
Item number 8. Future lots. The matter here is that the helper is claiming engagement of Hon'Ble worker, taking into account the experience and work.
Yesterday matter was there. Yes.
Another matter.
Acha.
Worship had sought for in like from the state and adjourning some of the.
When is it posted to? The other matter?
I think I.
Item 9. Kalir item 9 take book jaisi sei date record debe hala. List this matter on so and so along with tarkani sei dino khali thao.
The petitioner shall not be but participate consider his application.
हाँ सेही order टा ही कर दो. काली रो जहाँ order टा थिला item 9 रे सेही order टा को कर दी date टा को एका कर दो सेही date रे कर दो. हैला? Yes, Mr. Das.
Sir,
Same order will be passed on the same date. Yes.
9. In matter relating to Anganwadi helper selection, the petitioner secured hash mark on the ground that her certificate is not equivalent, but that they have treated it wrongly. They have relied upon a letter where I have the equivalent qualification and I had secured 76%, but the 60% mark secured who has secured she has been selected. So the equivalence टा annexure 5 series page 35 रे अछि एई लेटर टा से हम रेफर करछंती 11 September 2020 सेइतर लास्ट पेज 34 रे अछि पेज 39 members of COBSE मु बिहार संस्कृत बोर्ड रो this is my +2 certificate
Serial number?
56
No. 56 तो? अच्छा.
member of COBSE member of COBSE admitted on or before 24/9/2019 मोर सर्टिफिकेट टा होची 2018 ता पर लेटर टा देखंतु आज्ञा से जो पेज 41 all members of board council that are members of COBSE are equivalent to CHSC Bhubaneswar serial number 5 रे मु अछि मोन ए जो मो इंस्टीट्यूट टा अछि बिहार संस्कृत शिक्षा बोर्ड I have secured 75 सेटा किंतु से 2020 रो लेटर को
So you are challenging the engagement of the other person.
yes because
You and your non-selection. So file an appeal. File an appeal as per the new guidelines. The appeal provision is there. File an appeal.
but I pray that stipulated period appeal should be
Yes.
disposed of
Yes.
and any appointment subject to result of the appeal.
Oh, obviously. And no. Here, what I will say is that I will allow you, grant you liberty to make appropriate application, interim application before the appellate authority, which will be considered.
within stipulated period of time.
Yes. Before whom is the appeal?
Sub-collector.
Sub-collector.
And-
No, it is helper or sub-collector. Right.
yes.
Yes.
And 2023 guidelines.
15/3/2023.
Again.
Yes. The petitioner was an applicant for engagement as Anganwadi helper pursuant to advertisement dated 23/7/2024. Her candidature was apparently rejected apparently on the ground that the qualification acquired by her is not equivalent to the CHSC qualification of Odisha. The learned counsel for the petitioner, however, refers to the notification dated 11 September 2020 to submit that the institute from which she had obtained the qualification is declared equivalent with CHSC. Stop. This court, however, finds that this being a case of non-selection of the petitioner and selection of another person, who apparently who is said to have secured less marks than the petitioner, remedy of appeal. Remedy of appeal. The petitioner can invoke the remedy of appeal as provided under the revised guidelines dated 15/3/2024. Stop. When was it? Say 30 se 8 that time is. If
23.
na sir 24 30/8/2024 re
Guideline টা হচ্ছে
15 guidelines টা 15
ଭାଇର 15/3/2023 ତାଙ୍କର ଆପଏଣ୍ଟମେଣ୍ଟ ହେଇଛି 30/8 so within 1 month ବି ତାଙ୍କ ଟାଇମ ବି ଅଛି
ନା 60 days
60 days ତ so you have time in such way the matter the writ application is disposed of granting liberty to the petitioner to prefer appeal before the appellate authority under the revised. I will simply say appellate authority under the revised guidelines mentioned above. Stop. If such appeal is preferred along with any application seeking appropriate interim relief, comma, the same shall be considered and disposed of in accordance with law. Stop. Further, the appeal shall be disposed of within a period of 2 months from the date of its filing, after granting opportunity of hearing to all necessary parties.
And
What-
any appointment subject to result of the appeal.
ଆପଣ ଫାଇଲ କରିବେ ପୁରା ସେଠି
ଆଜ୍ଞା।
ସେଇଥିପାଇଁ କହିଲେ ଆପଣଙ୍କୁ ଲିବର୍ଟି ଦେଲି ଇଣ୍ଟରିମ୍ ଇଏରେ ଯଦି ଇଣ୍ଟରିମ୍ ଅର୍ଡର ଆପଣଙ୍କୁ ନ ପାଇଲେ ତାହେଲେ ହାଇକୋର୍ଟକୁ ଆସିବେ ସୋ ଆପେଲେଟ୍ ଅଥରିଟିରେ ଯଦି ଦିସ୍ କୋର୍ଟ ହୋଲ୍ଡସ୍ ଦ୍ୟାଟ୍ ଦେयर ଇଜ an alternative remedy how can this court now interfere so I have granted you that ସିଏ ଦେଇଦେବେ ଆଚ୍ଛା ଆର ମ୍ୟାଟର କ'ଣ
ସେକେଣ୍ଡଟାରେ ସିଏ ହଉଛି ମ୍ୟାରେଜ କରିଛି ଜଷ୍ଟ ବିଫୋର ଦ ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ତାଙ୍କର ରେସିଡେନ୍ସ ସାର୍ଟିଫିକେଟ ଅଛି ସବୁ ଅଛି ହାଷ୍ଟ ମାର୍କ ସିଏ ସିକ୍ୟୁର୍ଡ ସେ କହିଲେ ଯେ ସର୍ଭେ ରିପୋର୍ଟରେ ଯେହେତୁ ତା ନାଁ ନାହିଁ ତ ଦେ ହାଭ୍ ଡିସକ୍ୱାଲିଫାଇଡ୍
same thing the petitioner is aggrieved by her non-selection as Anganwadi helper and the selection of another non-selection apparently on the ground that her name does not find place in the survey list of the concerned village. Stop. This court observes that the petitioner can always that alternative efficacious remedy is available for redressal of such grievance as per the provisions of the revised guidelines dated 15/3/2023 of the government. In such view of the matter, se arata jaha order kar de seta kar do. Last se
ফার্স্ট আপিলেট অথরিটি তাଙ୍କର দুইটা আপিল ଅଛି সব কলেক্টর
ମୁଁ ସେଥିପାଇଁ appellate authority କହିଦେଲି ଆପଣ first appeal letter file କରିବେ you also have another round of going to the ADM. So why I need not say that. Referring to the guidelines enough ସେଥିରେ ଯାହା ଅଛି ଆଉ କ'ଣ ସେମ୍ ଅର୍ଡର ଏଥର ଆଠଟାରେ ଯାହା ହେଲା ଇଣ୍ଟରିମ୍ ଅର୍ଡର ଏଥିରେ ବି ସେ ଅର୍ଡର
ହାର୍ଡଟାରେ ହଉଛି ଆଇ ଆମ୍ ସେକେଣ୍ଡ
ହାର୍ଡ ଗୋଟେ କୋଉଠି ହେଲା
ତିନିଟା ଅଛି
ଓ ଥାର୍ଡ ଗୋଟେ ଅଛି ଆରି
2751.
yes what do you want
secured second highest mark but the first highest mark is secured she has not deposited her certificate qualification certificate only mark sheet ଦେଇଛନ୍ତି
ଏଇଟା କ'ଣ ଗୋଟେ ଗ୍ରାଉଣ୍ଡ ହବ
ହଁ ସେ ମାର୍କ ସିଟ୍ ଦେବେ ରିକ୍ୱିଜାଇଟ୍ ସାର୍ଟିଫିକେଟ ଦେଇନାହାନ୍ତି
ମାର୍କସିଟ୍ ସାର୍ଟିଫିକେଟ ନଥାଇ କ'ଣ ମାର୍କସିଟ୍ ହେଇଯିବ ପାସ୍ ନ କରିକି ମାର୍କସିଟ୍ ପାଇବ
ସାର୍ଟିଫିକେଟ ଟୋଟାଲ ଦେଇନାହାନ୍ତି ସେ ଏଥିରେ ଲେଖିଛନ୍ତି କେବଳ ସିଭିଲ ଇଞ୍ଜିନିୟରିଂ ମାର୍କ ସିଟ୍ ଦାଖଲ କରୁଛି ପେଜ 27 ସିଭିଲ ଇଞ୍ଜିନିୟରିଂ ଥିଲା
I don't understand
page 27
page 27 yes
ये जो राइट साइड राइट कॉलम फर्स्ट सीरियल नंबर 1 रे राइट साइड पूरा मंतव्य रे केवल सिविल इंजीनियरिंग मार्कशीट दाखल कर
look the petitioner is aggrieved by the selection of one Dukhi Kuwaro as Anganwadi helper mainly on the ground that at the time of selection she had not produced all the required certificates. Stop. According to the petitioner, comma, she being the second highest mark holder, comma, ought to have been selected. This court observes that the grievance of the petitioner can be redressed by filing appeal before the appellate authority as per the provisions of the revised guidelines dated 15/3/2023. बाकी जा ऑर्डर हला कर दो डिस्पोज ऑफ ग्रांटिंग लिबर्टी इंटरिम रिलीफ अप्रोप्रिएट
रे वन थिंग दैट से जो सेंटर नाटा लिखि देले सुता
लिखि दो ना अंगनवाड़ी हेल्पर ऑफ अमोक सेंटर सेरा सबुथिरे तीनटा कर ऑफ अमोक सेंटर यस
Petitioner contractual supervisor in ICDS project, Rajnagar. The government
supervisor
contractual government on 22/12/2014 refused to regularize 557 contractual supervisor service and allowed them to continue at the remuneration of 9,200 per month. No service unit, nothing, my lord, government service. They will not govern by the Orissa Children and Women's Service Rule 1989, my lord. Now, the collector has transferred me from Rajnagar to Kendrapada. There is no transfer policy. A contractual employee cannot be transferred from one place to another. Rule does not provide, that rule is not applicable. No guideline there to transfer my service from one place to another. And I rely on one decision of this honor court on similar cases, your lordship.
And
If there is no rule and there is no guideline, contractual guideline, the contractual employee cannot be transferred from one place to another. Lordship, I will come para 18.
Para 18.
At page 18.
Yes.
If such clarification, the officer for the purpose of rule as beneficiated under clause 2 of the appendix B is taken into consideration, it also does not speak about the employee engaged on contractual, that is the rule is applicable to that employee. Contractual basis, rather clauses 3 and 4 of clause A states about all employees appointed on lump sum contract, that by itself cannot construe that employees who have been engaged on contractual basis. Clause 3 of appendix B deals with the entitlement of class of the accommodation for travel. Therefore, if a close scrutiny would be made to the provisions contained in Rule 3F, read with the clause 24I and appendix B. Nowhere it has been specified with regard to transfer of contractual employee engaged under OPEPA and OSCE. The travel allowance which is additional under Rule 22401 is only applicable to the employee indicated in definition 3F, and as such, the same does not include the contractual employees engaged under OPEPA and OSCE. Thereby, OPEPA service rules and regulation 1996 being silent about the transfer and implementation thereof. Any transfer of contractual employee made is in violation of such rules, and the same cannot sustain in the IF law. Then para 26. At page 33. If the issue involved herein is considered from the angle, in the absence of any provision contained in OPEPA service rules and regulations 1996 for transfer of contractual employees, there will so-called guidelines issued on 17/12/2018, as well as the proceeding of 36th Executive Committee meeting on of the OPEPA held on 21/3/2018, which lacked quorum. The informed orders of transfer passed by authority concerned is without jurisdiction. Here, my lord, I have brought the rule. You will see that rule is not applicable to us. We are contractual employees, and they have made clarification. You will also kindly see annexure to my lord. Comment report to regulation at page 9. Para. In the meantime, state government have taken certain policy decision regarding service condition of contractual employees by the above deferred notification and resolution of GA department. Considering the policy decisions of the state government, clarification is being sought for from the various quarters on the following points. Whether these 557 contractual supervisors will be regularized on completion of the 6 years of contractual service, whether they will be entitled for grade pay during the contractual service period, whether their consolidated remuneration will be enhanced by 10% of completion of each year of the contractual service, whether they will be entitled for leave and pension at par with the regular employee of the state government. The answer is at page, next page, clause 4, my lord. Service benefits mentioned in the notification and resolution of GA department referred above applicable to contractual appointment made as per the relevant recruitment procedure rules prescribed for a corresponding regular post. If any contractual appointment has been made without following the relevant recruitment or procedure prescribed for the corresponding regular post, service benefit as contained in the above mentioned notification and resolution of GA department cannot be extended to such contractual employees. Therefore, it is hereby clarified, since engagement of 557 contractual supervisors is not as per the relevant rules, They are not entitled to any service benefit as mentioned in at paragraph 2 of this letter, my lord. Then, my lord, clause 7, next page. The contractual supervisor, though not entitled for the service benefit as mentioned at paragraph 2, this letter, will however continue to function as such or the same for the time being with a consolidated remuneration of 9,300 per month till further. That is a meager amount. I will be transferred to another place. How can I certain money? There is no rule for my transfer. We are not regular employees and we will not get any service.
But my learned friend may be having a very good case, but now the difficulty is Annexure 3, your lordship will kindly find. It is like a group transfer.
That is the regular employee along with
So
the
in
regular.
case your lordship now passes an interim order that may
In
cause
respect of-
disruption, may I pray your lordship may direct the collector and district magistrate Kendrapada to look to the matter and the submissions and the documents relied upon by the petitioner.
I think question of law, my lord, decided by this on what I am giving them.
Because Pratibha Mahanti, your lordship
I am
will.
only the contractual.
A regular person, that Pratibha Mahanti.
No, that of course I have no instruction, but Pratibha Mahanti, supervisor Rajnagar ICDS project, he is hereby transferred and posted as such to ICDS project Kendrapada.
After that,
Now from Kendrapada, somebody has also
two
been,
persons have been,
yes. So,
2 persons.
Sami-
have been posted. 2
So
persons
already relieved, they have already been relieved,
centrally relieved.
centrally relieved.
Not from the, I have not handed over charges, that is. Till yet, I have not been relieved by the city.
No, but what the state council says appears to be reasonable. You can
They will
approach the
not
collector.
consider my, you lost me decide my. lord.
No, why should I decide?
with a direction from this honorable
You
court,
lost me
consider
decide
calling.
direction, they will not decide. My lord, the question of law, I have
Not
given
decide.
the rulings of
This may not be applicable also.
Well, that is.
Strictly speaking, may not be applicable.
My
This
lord,
is
because-
relating to that OPEPA and OSEPA, that's a different
OPEPA,
matter.
they are the contractual employees here in OPEPA. They said the rules is applicable, that this honorable court interpreted that rule of the applicable to the employees of OPEPA are not.
And again, it is not a very far away place from Rajnagar to Kendrapada. How?
300 ଟଙ୍କାରେ contractually ଯାଇ କୋଉଠି ଘର ଭଡା ନେଇକି ରହିବ ରହିକି ସେଇ ଲୋକଟି regular employee ହେଇଛି କିଛି no objection. Contractual employee should not be transferred from one place to another.
This order
No
having,
rule is there to provide for transfer of service. If a lawsuit will not decide, my collector will decide. Collector will.
he will be
pass the order.
directed to decide.
He has passed the order. I have challenged that order.
No, he has passed that order, but he can. He can always consider the fact that there is no provision for, the rule does not provide for transfer. So that
Rule
part
is
also he
not
can consider.
applicable. They said that in the rule, my lord, you lost it. I will see this rule, my lord. This is applicable to the supervisors. This rule is not applicable. They have said in their notification. I am not saying.
This rule is not applicable to them.
They have said that this is not a rule is applicable. We are not regular employees, no service benefit, nothing is applicable. To only on the consolidated salary of rupees 9,300 will continue till. Whatever they want the period, they will decide.
No, this is a group transfer. That is the problem.
Yes.
Transfer, I am contract, others are regular employees, they can go, I can, others are not contractual employees.
But the
But I'm
person,
granting you 10 days time. To obtain instruction, specifically on this aspect, that when the rules do not, under which rules they have done it. If the rules do not permit for transfer of an contractual employee,
Yes.
they cannot be transferred.
but in the meantime, the difficulty will be if the meantime this has already been given effect to.
No, I have not.
I would say that if not already given effect to, insofar as the petitioner is alone is concerned.
Yes.
Others I will not touch.
If I have not been released by the CDP or charge has not been handed over.
That's it.
Her reliever from Kendrapada, he
I have
has,
not joined it.
no, that is your.
Yeah, that I will say the subject to. We always say subject to the fact that anyway. Sri M.K. Mahathir, Learned Counsel for the petitioner, submits that the impugned order of transfer is unsustainable in the eye of law for the reason that law there is no rule permitting transfer of a contractual employee drawing a meager salary drawing a meager consolidated remuneration. Stop. He has cited the judgment passed by a coordinate bench of this court in the case of Sashikanta Mishra versus Rajashree Patnaik, so and so, wherein a similar view was taken. Learned State Council shall take necessary instructions in this regard, and particularly on the points raised by the petitioner. Stop. Let's this matter was in Parvara on 26th September. In the meantime, आइए record. The order dated 3/9/2024, only insofar as it relates to the petitioner, कौन था ना?
Pratibha Mahanti.
Pratibha Mahanti, shall not be given effect to, comma, if she has not been relieved, if she has not been actually relieved from her post
And handed over the charge.
by handing over charge. Yes.
And her reliever has not also arrived.
I would say hand over charge है ना?
Handing over charge only.
I would request my lawyer friend to give a citation copy.
Yes, I will give you.
I don't know, 11 pattern matter.
A copy of your lordship.
A free copy of this order be handed over to the State Council.
Item 11 on behalf of Mr. Rautar, kindly pay for a pass over, Your Lordship.
Hold it, pass over.
I don't know, 12.
And for the.
Yes.
Item 12, may I please? Sir, I'm praying for my lordship. Allow me some time, my lordship, for further hearing, my lordship.
This is a part matter, 2014 matter.
One adjournment, my lordship. Allow me.
Why?
I'll intimate Mr. Rai, PK Rai, who is appearing in the case, my lordship, conducting counsel.
Last time
Was-
taken for
was,
his pen like that.
Cardiac
This
problem.
time,
Cardiac operation is ସେଥିପାଇଁ
Cardiac operation is.
ହଁ ତାର ଲାଗିଛି ଗୋଟେ
last time for that reason, my lord.
Press
granted
paper.
time.
All right, list this matter next week as paid for. It is made clear that no further time shall be granted. Yes. Next week.
I don't know, 14.
13 कौन लगी?
Next week.
14 also paper pass over.
All right, pass on.
I don't know, 15.
15 my lord, file not test out my lord, pray for next week my lord.
2010.
And I am in first case my lord, I am petitioner my lord. Second case I am file ଟା ମିଳୁନି ହଁ ଗୋଟେ ରେ ଆପଣ ଦିଟା କର
Learned
for
counsel
next
for the
week, my
petitioner requests for an adjournment on the ground that the file is not traceable in his office. Is this matter next week?
I don't know, 16.
Next week.
And various objections.
It is a details.
The case of the petitioner, so can you petitioner filed the seat application for passing the order of removal dated 28/9/2011 by the annexure 17 and allow him to continue as a professor in PG Department of Sociology and pay all the area and financial service benefits retrospectively. Now, tell you what third date, Marasol, 29/8/1996. Petitioner was selected through open advertisement published by the Utkal University for the post of reader in sociology and joined in the said post. And 19/7/1999, after completion of probation period of 2 years, he was confirmed as reader in the PG Department of Sociology with effect from 29/8/1998. Then, my lord, she was promoted to the post of professor in sociology under career advancement scheme in 2007. with effect 3/8/2005. Then on 28/9/2007, petition was selected at Unimas, Malaysia, and applied UL for 3 years and submitted representation to the opposite partner 3. On 9/10/2017, CL, EL, and UL applied for by the petitioner from different period. That is 9/10/2016 to 6/15/2007 was allowed by the university to draw his salary and accordingly. On 8/11/2007, UL application was sent to the chairman and HOD. On 19/11/2007, petitioner joined at Unimas, Malaysia as the academic session was started. On 30/11/2007, UL application the petition was placed before the syndicate of the universities. And on 25/3/2008, syndicate submitted the same to the Teachers' Council, in which it was resolved to occur 2 years earlier, but no intimation was given to the petitioner. On 17/2/2009, opposite partner 3 issued a letter to rejoin its duties within 1 month, pending finalization of sanction of leave for unauthorized absence and failure to resume duty. Action will be initiated against him. Then on 27/3/2009, petitioner submitted reply that his contract was for 3 years, so allow him to continue till November 2010, or at least till the end of academic year 2009-10, and save him from the embarrassment. And 31/3/2009, opposite partner 3 issued a letter to rejoin its post within 15 days, telling it the period of absence would be treated as unauthorized absence, and that may be treated as last reasonable opportunity. On 16/7/2009, the opposite partner 3 issued a second show cause notice that application made by him for grant of UL till November 2010 was rejected, and explained why service from the university will not be terminated with effect from 16/11/2007 in terms of Rule 13, 14, and 15 of the OCSCC rules 1962, and in case no show cause reply is received, matter will be decided expertly to terminate his service from 16/11/2007. On 2/9/2009, petitioner submitted his joining report at Uttar University, attaching relieving order from Unimas, Malaysia. Then, my lords, opposite partner 3 accepted the joining report of the petitioner with effect from 2/9/2009, and question of regularization of his leave from 16/11/2007 to 1/2/2009 will be decided later on. On 13/12/2009, petitioner took medical leave from 12/11/2009 to 22/11/2009 and submitted his joining report in 23/10/2009. And 6/5/2010, petitioner was not assigned any teaching job but allowing to official work, which he applied leave on 5/1/2010 and joined on 6/5/2010. On 9/6/2010, hard show cause notice was given to the petitioner as to why his joining letter dated 6/5/2010 will not be rejected and why his service will not be terminated as misconduct, explained within 15 days. Otherwise, disciplinary action will be initiated ex parte to terminate his service on 2010/2009. And next, my lord, the petitioner submitted the explanation that I applied UL for 3 years, which has been approved by the Teachers' Council. He requested for VRS for the university last 14 months, but due to bad health, no reason from the side of the university, no response from the side of the university. Earlier, leave period was already sanctioned by the university, and he had drawn the salary. On 26/7/2011, opposite partner number 3 communicated that the petitioner that the syndicate in its meeting dated 15/9/2010 appointed an inquiry committee headed by the chairman PG Council Uttar University to investigate this case in details, and the committee submitted its report on 24/2011, in which neither he responded to the summons and notice nor speak anything in its defense, and therefore the committee recommended for termination of his service and as a last issue, and he was advised to say his defense to the Vice Chancellor either in person or in writing within 1 month, following which the action shall be initiated expiry. And 22/8/2011, petitioner made the opposite partner 2 in the chamber and requested to join in the university or else allow him to voluntary retirement. And 28/9/2011, of which is the interim order, my lords, the opposite partner 3 communicated an office order to the petitioner that he was removed from the university service with immediate effect as specified under statute 301 read with Statute 20299 and 247 of the Orissa University First Statute 1990. Eight matters I appealed it before the Chancellor, and the Chancellor matters I have Chancellor matters. Letter matters that is on next page matters 1/11/2011, 24/11/2011, 2/2011. Petitioner applied under RTR with regard to result of his appeal, as it was disclosed that direction was given to the opposite partner 2 and 3, that is Registrar and Vice Chancellor, to furnish the parwise comment on his appeal petition, along with copies of the relevant records relating to initiation of DP against the petitioner. But there is no response from the university till date, for which the Honorable Chancellor has not been able to dispose of the appeal, which is the statutory under University Act 1989. Then on 23/8/2013, Additional Secretary to the Chancellor wrote a letter to opposite partner 2 to the Honorable Chancellor, has been pleased to order that the petitioner should be allowed to work within a week's time positively. In case there is any legal constraint and the petitioner cannot be allowed to rejoin in his post, the matter should be explained in detail by the registrar within a week, and the petitioner received the same letter under RTI matters. Now, matters, the entire Vivak matters, I am showing matters 3 annexures matters. Annexure matters, that is that annexure 11 page 23 matters. Page 23. That is matters, that is they have registered. Registrar has wrote a letter matters. The register, that is by page 24, last portion matter. Thus, you are hereby directed to show cause as to why your joining letter dated 6/5/2010 will not be rejected, and why your service will not be terminated with immediate effect. That is the third show cause notice matters. That is the third show cause not be rejected for gross misconduct as stated above within 15 days of receipt of the letter, in which it will be presumed that you are nothing to substantiate. Disciplinary action as deemed fit will be intimated, and matter will be settled expertise to terminate your service matter. That is on 2010/2009. The disciplinary action will be taken, but no action has been taken by us. Then matters annexure 16 matters, page 30 matters. Again, the registrar wrote a letter matters. That is matters of the second paragraph. Your attitude and behavior have caused a serious rupture in the academic as well as administrative activities of the university, since your frequent and unauthorized absence from duty amounts to gross misconduct and violation of official decorum. The university syndicate has meeting dated 15/9/2010 resolved to appoint an inquiry committee to look into the matter and to suggest the lines of disciplinary measures to be followed in your case. Accordingly, the committee under the chairman PG Council University was appointed as the syndicate, investigated into the detail of your case. The committee submitted its report on 24/2011, wherein they have mentioned that you did not respond to the summons and notice, and as such did not reply to your queries of the committee, nor did you speak anything in your defense or in your claims either in person or in writing. The committee, after thread discussion and detailed observation, has found out all your charges and allegations against the university supported by sufficient reasons. Further, the committee also recommended for termination of your service in order to put a logical conclusion of the matter. Prior to initiating a disciplinary measures against you, as per rules, as a token of last resort and relief, you are advised to speak anything you have to say in your defense to the Vice Chancellor, either in person or in writing, within 1 month from the date of issue of the letter, telling which it will be presumed that you have nothing to say and such action has been deemed to expiry. Next matter is termination. The removal of data matters. Annexure 17, page 32. The Vice Chancellor, in exercise of the powers conferred under Statute 302 of Orissa University First Statute 1990, he removes Dr. Balagovinda Babu, Professor, Career Member PG Council Sociology University from University Service, with immediate effect as specified under Statute 309, read with Statute 299 and 247 of the Orissa University First Statute. I am showing the statute matters. And the statute matter, that is the teachers matter, that is Rule 22 Clause 2 matters. Page 19, first page. The teachers of the university, because the teachers of the university shall be appointed by the syndicate of that university on the recommendation.
You are reading from? Yes, sir. Clause 21 or 2?
Clause 21. The teachers of the university shall be appointed by the syndicate of that university on the recommendation of the selection committee consisting of the concerned vice chancellor, director, and expert nominated by the chancellor in case of appointment of professor, and 3 experts selected by the vice chancellor from out of the list of 6 experts furnished by the syndicate, who shall not include any teacher of the university or any continuous affiliated colleges, so and so. So syndicate is my not syndicate is my appointing authority. Then my lord, then turn to my lord, that is clause 247. That is at page 87. To the following acts and omission or commission shall be deemed to be constitute misconduct, which may entail disciplinary action, namely negligence or failure to perform, such as. Then my lord, sir, then page 103. The rules, my lord. Application of government rules and classification. Rule 12, 40, 15, and 16 of the Orissa Civil Service Classification, Control and Appeal of 1962 as amended from time to time, and the government clarification issued thereunder in the matter of suspension for imposing major and minor penalty. That is, my lord, they will apply to the OCS rule 1962, my lord. And with regard to my lord, that 301, my lord, that is with regard to nature of penalties, and down to 302, my lord. That is 302. The appointing authority, because it is the case of a reader or professor, the appointing authority is syndicate. The appointing authority may impose any of the penalties specified in statute 301. That is nature of penalties. Without prejudice the provisions of substatute 1 above, any of the penalties specified in item number 1 to 5, that is minor penalties of statute 301, may be imposed by the employees of the following may be imposed on an employees on the following officers, that is vice chancellor in respect of employees appointed by the vice chancellor or syndicate members, and register in case of class 3 and class 4. So that with regard to matter, that removal is a major penalty as per 301 of the statute matters. So only the syndicate has the power to remove me matters from the service after taking into a disciplinary action matters, but without issuing any charge sheet, without issuing any explanation, my lords, that the register, the vice chancellor has passed that order, taking into reports of law, that is that they have submitted, that they taking reports that statute 301 statute 299 and 247 of the Orissa industry, but without any proceeding initiated against me, without initiating any.
What happened to your appeal? Ultimately, what final order was passed?
Final order has not been passed, my lords.
But there was a direction to reinstate you in service?
Yes, that is the order, my lords. That is the order of the chancellor, my lords.
Yes, that is what you were pointing out in your date chart. What happened to that order?
They have not reinstated, they have not issued any DP file, my lords. That is, my lord, that is at page, running page, my lord, 59. I have obtained the document through RTA Act. 59. I am directed to say that Honorable Chancellor has expressed his displeasure over several acts of injustice that are occurring, as it is the case of Professor Balagovinda Babu, Department of Sociology, Utkal University, Banibia, Bhubaneswar. Professor Babu was granted private audience on 8/8/2013, and Honorable Chancellor has been pleased to order that he should be allowed to work within a week time positively. In case there is a legal constraint or any other matter for which Babu cannot be allowed to.
No, Mr. Ponda, you have already read it in your date chart.
Yes.
The problem is the appeal is still pending.
No, appeal is, my lords, that is, my lord, I am citing one judgment, my lords.
Yes, judgment
appeal is pending thile madhya. If they will violate entire the statute, my lord, the Orissa University statute, they have violated. Whether the under 227(6) of the writ application, whether the court has power to.
You see, simultaneously, two courts or two forums cannot deal with the receipt.
Because
now, when the appellate authority, the Honorable Chancellor is in session over the matter, rightly, wrongly, he has not passed any order so far. This court can at least direct the Chancellor to pass an order.
The Chancellor directed the university to produce the DP file. They have not produced from a.
No, I will ask the State Council now. Who's for the university? You are appearing.
I am on behalf of Mr.
So what has happened to that appeal? And who's appearing for the Chancellor? Chancellor is a party here.
No, Chancellor is not a party.
Yes.
Oh, sorry, Chancellor is a party.
Chancellor, who's appearing for the Chancellor? Usually Mr. Udgat appears. This is a peculiar situation. There may be judgments, but they can be distinguished very easily on facts. when the appeal is pending, he has not passed any final order on the appeal.
And even though, my lords, even though Chancellor directed him to produce the DP file, my lords, I have got
That I've seen, that I've seen. That I will ask them the question.
That
What stand have you taken in your counter?
They have
I will
taken-
take instruction, my
they
lord,
have taken
regarding
only
that
down
whether
that the appeal is pending, nothing else.
No, that is what, whatever you have shown,
my lord.
the matter seems to be pending before the Chancellor.
Yes,
Chancellor has not passed any order either way, either accepting or rejecting your appeal. So, in such a situation, why will this court interfere?
No, Chancellor directed to produce the DP file. Chancellor directed to allow him to work because in the meantime,
So that is between the Chancellor and the Vice Chancellor. If the Vice Chancellor does not obey the order of the Chancellor, it is open to the Chancellor to take necessary action. The Chancellor is not helpless. Chancellor is not helpless, sir.
and in the meantime, my lords, in 2015, my lords, I have superannuated from my sons.
No, and there are, somehow this file has not been taken care of. But I think in the governance establishment, as Chancellor, all the files are taken care of. Some order is usually passed.
No, my lord, that is my lord, so I am showing one letter, my lord, and Chancellor directed him to produce the DP file.
No, this is very surprising.
Yes.
This is very surprising, and I would ask whoever is appearing for the Chancellor, let us see.
Just I am showing one letter, my lord, that is page 62 of the letter. Page 62 through 38, page 62.
Mr. Dayananda Mahapatra is appearing for the university.
University, my lord.
Ask Mr. Dayananda, where is he?
My lord, he is in the chief court, my lord. Matter is going on. One matter is.
कौन कहले कोई टाइम में कोई इंस्ट्रक्शन पूरी कोई टाइम नहीं जीवना
ना
तो कौन कहले
my lord,
बिल्कुल भी टाइम देबिन
ना टाइम मागुनी my lord. ପାଠର ଯଦି ରଖୁଛନ୍ତି ରଖନ୍ତୁ କାଲି କି ରଖନ୍ତୁ କାଲି ଆମେ ଇନଷ୍ଟ୍ରକ୍ସନ ବି ନେଇ ଆସିବୁ କଣ ଅପଡେଟ୍ ଅଛି ମ୍ୟାଟର ରେ ସେ ଅନୁସାରେ କାଲି ଡିସ୍ପୋଜ ଅଫ କରିଦେବୁ.
This is a very strange matter.
My lord.
Very peculiar situation.
କଣ ଅପଡେଟ୍
The matter, the Honorable Governor may have, or the Chancellor rather, may have completed the inquiry, or the appeal he may have concluded the appeal.
No, my lord.
Some order may have been passed.
My lord, counter is of 2016.
Yeah, I got the information, my lord. Note, because Chancellor has not disposed of the appeal, my lord, page 62, my lord, just for a moment, page 62.
62.
Yes, my result. Appeal petition of Professor Balgomdo Babu. I am directed to invite a reference to the office letter show on the above, wherein you are requested to furnish parawise comment on the appeal petition.
No, this is in 2011.
2011, no, that is 2000, yes, 2011.
Yes.
This is 2011. We have filed the counter in 2016. So I will take a fresh.
No. 2000. This is between you and the Chancellor.
Yes,
the Chancellor called for the disciplinary proceeding file.
Yes.
Whether you have given or not, since there is no disciplinary, according to Mr. Panda, there was no disciplinary proceeding. So there was no file. But
what is the DP file?
I'm surprised that this matter may have escaped the attention of the Chancellor in the 2011. Who was the Chancellor?
2011 and 2013 also, my lord. That is a phase, my lord. 2014, page 57, my lord. I have shown that. That 2014, they have supplied the documents to RTA Act, my lord.
I have worked as legal advisor to the governor for 3 years.
And in the meantime,
So I know these files, how they work and how they move. I know how they, but this is very surprising.
and my lord, interesting, my lord, in 2020, my lord, when was my lord was the secretary in the law, my lord, rule 22 and 22(1), my lord, that has been amended.
I will not say anything about that. Tomorrow.
My lord.
Third and part is this matter tomorrow. Tomorrow we will, but if it is pending, Mr. Panda, irrespective of what judgment you are going to show me, I will be very slow in interfering. If the Chancellor, who is the appropriate authority, if he is insistent over the matter, this court should not interfere at all. Maybe I do understand 2011 matter, but still then it has to be regularized.
I am showing you one judgment, my lord, if my lord passed that.
All right. Tomorrow, huh? କେତେଟା ଅଛି କି? ତାହେଲେ ରହିଯିବ ପାଠାଡି କି ରହିବ କଣ? Pathad. Ask Mr. Mahapatra to appear.
Yes, ma'am.
And Mr. Panda, can you find out who is appearing for the university? There's nothing mentioned in the file.
Chancellor.
I'm sorry, the Chancellor. Maybe the file may have been transferred to Mr. Udgata also. Find out. Find out.
I don't know, 17, my lord, we are collecting some documents, my lord.
filing adjournment for next week.
Well, next week as paid for.
Item number 18.
May I please your lordship? This is a case, your lordship, that a petitioner retired in the year 2015. Now this is 2024. He is not getting any pension. Day before yesterday, your lordship passed order directing the additional government advocate to take instruction. Why for this technical reason that fellow is suffering for.
In this matter?
My lord, in this matter, your lordship.
Oh, yes.
I have got the instruction. Your lordship may.
Oh, let me read my order. In course of hearing, attention of the court to attend Annex G. The letter dated 9/8/2000 written by the Registrar of University, Special Secretary Government seeking reconsideration of the matter. Legal opinion is retired way back into it. It's not a matter of regret. Yes.
Since 2012, government has instructed the university that you are to bear your own expenses.
Then that is enough.
So as your lordship would consider.
So the university will do the needful, isn't it?
So this is that your lordship had directed.
You have got your license, Mr. Patnaik, from the government. You wanted a license from the government. The government has given you.
So that is all right, but
I am directed to say that by this department, letter number so dated 10/10/2012. Copy enclosed. The copy is also there.
Yes.
It has been directed to make necessary payment of salary and other allowances to the petitioner from the university's own resources without any financial burden on government. So you do it. A low-paid employee.
so in that I have submitted before your lordship that this was a letter for reconsideration of their.
So that reconsideration has been regretted, reiterating the earlier decision. So you have to abide by that decision.
In that case, there will be no other choice.
No. 2015. You give him a copy. Give him a copy. If you want, I can adjourn it to tomorrow. Give him one opportunity. Let him go through.
Come on Monday. Sorry, Tuesday. Monday.
No, phone you tell them, just warn them that mandamus is coming out.
My employer is university. He will pay. That is.
Because very simple. Government has given you a clear signal. Isn't it? Reiterate, this particular reconsideration was regretted.
Exactly.
But this does not take away because they have reiterated their earlier stand, which says that you have to meet from your own resources. You have to meet them. A budgetary allocation kariye, supplementary budget nebe paisa au kono.
They have also made a budget provision for 100 course. That is, I have.
We'll see that. We'll see. Tomorrow we'll pass that order. If necessary in the open court, I'll pass that order. Item 19.
Item number 19.
Ketaraj. Chup. Yhi to Ketaraj. Yes, Mr. Acharya.
Not the case of the petition, but counter not filed, but from the.
2013 counter darkar.
Darkar because similar case, you also already delivered judgment. Same fact that TBA scale, whether it is coming under the, they said is a compensatory.
Oh, that incentive thing.
Incentive.
I've already, is it covered by the judgment? Have they not challenged it before the higher forum?
That reported 2024 2LR 572. Either appeal
Yes.
filed or not. If not appeal filed.
Sri P.C. Acharya, Learned Counsel for the petitioner submits that the case of the petitioner is squarely covered by the judgment passed by this court. In the case of Doitari Raut and another, you are conducting this matter. Doitari Raut and another versus State of Orissa reported in 2024 2 OLR 572. Learned State Council shall take instructions in this regard and apprise the court accordingly. Leave this matter next week.
Difference over second SCP third SCP because you are all completed 30 years.
No, principle have changed. We are on the principle. Whether it can be treated as an incentive. I have held that it is not an incentive. It is not an incentive, but it is a part of the pay because there is an upgradation. There is an upgradation. Upward raising of that. I have referred to the definition of I think Black's Law Dictionary and other.
बहुत कथा আছে।
Yes.
Mr. পটনায়ক এই যদি
I don't know, don't think.
What? He's the defeated candidate or what?
Yes.
he
I am the
conducting he মানে counsel my
So,
now my
so he's the defeated candidate.
ସେଦିନ ଗୋଟେ ୱାର୍ଡ ଟେ ୟୁଜ କରାଯାଇଥିଲା ଆଜି ଆଉ ଗୋଟେ ୱାର୍ଡ
କଣ କଲେ ସେ? He has lost the battle. Since I'm hearing election matter, so I'm now talking in those terms. Either winning candidate, losing candidate, electoral. Yes, Mr. Lenka.
On the last occasion, my learned friend, Mr. Maharana, was appearing for the private.
CDPO conas to the effect that Godo Bado put Anganwadi Center has been bifurcated as Godo Bado put 1A and Godo Bado put 1B. Both the Anganwadi centers, Anganwadi workers have been engaged since 8th. Private opposite party number 5. Who's
Your Lordship, I'm appearing for Mr. Maharana on instruction for a private opposite party number 5. We have no instruction to proceed in the said matter, and the subsequent item
You have no instructions to?
proceed in the present writ petition. The party does not wish to pursue this writ petition anymore.
But you are not the petitioner?
So the opposite party does not wish to proceed in the
You want to contest?
contest in the first matter.
Because she has already got service somewhere. That is the.
No, that is not relevant here. We have to find out whether the petitioner has a case or not.
Yes, yes. Petitioner, my lord, she was appointed.
No, then I can only say that she's not. There is no instruction as she's not because previously there was a judicial order.
Only because, my lord, I was removed from the service because she filed the review petition challenging the judgment by virtue of.
But now she has been engaged elsewhere.
Elsewhere, that apart, my lord, the Anganwadi center for which she was contesting. has
No,
been
Mr. Lekha,
bifurcated.
let us regularize it. Let us say
Yes.
that according to her instructions, she does not want to contest this matter. So, we will proceed.
Yes, sir.
What is your good name?
Rupreekha Jana.
Ruparekha Jana.
Yes,
For?
On behalf of Mr. L.K. Maharana, who has instructions to appear for private opposite part number 5.
All right. Miss Ruparekha
Jana.
Of course, you are pronouncing it in a different manner. I am pronouncing it in a different manner. I hope it is not wrong. Miss Ruparekha Jana, learned counsel appearing on behalf of A.K. Maharana. Sri A.K. Maharana. The counsel for the private opposite party number 5 submits on instructions that the private opposite party is no longer interested to contest the writ application. Stop. Yes. So you begin.
So, here, my lord, your lordship have a glance. The annexure 13 is my. In the year 2007, I was appointed. My lord, it's better I should begin from this time. The lordship may turn to page 25. In the year 2005, a petition was filed by the petitioners claiming the post of Anganwadi center, Anganwadi worker in respect of that Goda Bodaput Anganwadi center. Subsequently, same has been bifurcated to 1 and 2. Goda Bodaput 1 and Goda Bodaput 2. Both the posts have been filled up. So far as the present petition is concerned, that post has not been filled up. In page 25, lots will get the collector was directed to consider the case of the petitioner, taking into consideration that whether any reservation for physical handicap in respect of Anganwadi center can be considered or not. Then the lordship may turn to page 29, my lord, the direction of the collectors. Considering the materials on record and last paragraph, considering the materials on record and in view of the facts stated above, I am inclined to accept the candidature of the petitioner for selection as Anganwadi worker in Godapatapun Anganwadi center. Hence, the petition is allowed. The CDPO Konasa is directed to give her appointment as Anganwadi worker within a month of this order. Despite that, my lord, no appointment was given to her. And again, the petitioner approached this honorable court, and your lords will get the order at page 34.
Yes.
In view of the above, I dispose of this petition with a direction upon the CDPO Konasa to open number 3 to issue appointment order to the petitioner for being appointed as Anganwadi worker in Godapaduput Anganwadi Center under Konacha block within a period of 7 days from the date of production of the certified copy of this order as directed by the collector in his order quoted above. In the event the said order has not been superseded by order passed by any appellate authority in the meantime. Thereafter, my lord, I was given appointment. You lords will get at next page. I was given appointment and I was allowed to continue in service. I also given the necessary training that certificate I have annexed. That when at that time the opposite party number 5 filed a review petition, that is review 21 of 2007, challenging the order passed in the second petition by virtue of which the direction was there to the CDPO to give appointment
Within
as per
7
the
days.
direction of the collector.
Yes.
Only because that review was pending, my service was terminated. Since this, and the lordship will get in the order passed in the review, your lordship may turn to page 75. The order passed in the review petition.
75 of
the counter.
75 of
Page 75 annexure.
kahar.
So this court did not interfere with the.
Oh, however, if your lordship may place that, if it is possible to appoint the.
Paragraph in this review petition by order dated 5/4/2010.
In this review petition by order dated 5/4/2010, this court directed that pursuant to the subsequent advertisement, one post of Anganwadi worker in any of the center of Godapaduput 1A village shall not be filled up till the next day. Lord Council for the state is directed to take instruction as to whether the review petitioner can be adjusted in any other center in spite of the fact that her residence is beyond operational area of the said Anganwadi center at Godapaduput 1A. As such, bar was not available when the petitioner was selected and secured first position in the selection list. If it is possible to appoint the review petitioner in the said post in any such center which is nearer to her residence, such appointment shall be issued to her, since that will bring an end to the litigation in review petition as well as WPC number such and such. Such appointment shall be subject to the final result of the writ petition being WPC 3061 of 2010. Thereafter, my lord, the lord to get annexure 13 was issued. In fact, there is no order in that review petition that the petitioner should be removed from service. But on misinterpretation of the subsequent event that, but since no instruction was given, another contempt petition was filed. Only because the contempt petition was filed, I was removed from service. And the lordship may annexure 76, page 13.
Yes.
The improve. Ete द्वारा आपन को जने दिया जाउचे contempt number 39911 and review petition 21 2007 and WPC 528 of 2005 रे मान्यवर उच्च न्यायालय कटक निष्पत्ति क्रमे एवं जिलापाल पुरी को आदेश संख्या सच अनुଯାयी आपन को अंगनवाड़ी कर्मी पदरु बहिष्कार करागला.
देखिए ऑर्डर भीतर किए पाछे बाहर कर दवा था
विदा करिवार कोन जे ओनली बिकॉज़ कंटेम्प्ट ता फाइल हे गला से मते से तापर से.
So now the question is, has that post been filled up?
No, man. The bifurcated 2 posts have been filled up. So far as upon Anganwadi Godapaduput Anganwadi center is concerned, that has not been filled up too.
You find out that
that order is there, man. I have given.
Good is.
IA move file करके I have brought to the notice of this honorable court. That is IA number, discuss number 20668 of 2015.
Annexure कितने?
Mr. 22986 of 2015. Read picture. ସେଥିରେ ମୋ ଚାର୍ଟଟା ଖାଲି ଅଙ୍ଗନବାଡି ହେଲ୍ପର କୁ ଦିଆ ଯାଇଛି ସେ Annexure 16 ସେଟା କରିଥିଲି.
So the only thing that appears to be done is interpretation of the 3 orders passed by this
of
court.
this onward.
First, there are two writ applications and one is the review application. Nowhere there is a direction to disengage the petition.
Yes,
The only direction that appears to be material to the case is that
to consider.
the review petitioner may be adjusted in some other place. And now she is not contesting the matter. So what can be done?
Direction to the sub-collector to consider under the circumstances and pass an,
Not why consider? Why consider?
as your lordship would direct.
Because originally she was selected, she was appointed. Because of the pendency of the review application, and this is the order of because of that contempt application and review application, and there is review order, there is no direction to disengage her.
Yes. Pending. Yes, it is.
So there are now 3 Anganwadi centers. Godabada put 1, Godabada put 2. Yeah, to?
And the OP number 1 was coming under Godabada A. And since she got service somewhere, she allowed her sister-in-law to be appointed in that, and she has also.
No, there are 2 centers. That one center was bifurcated into another center. So both became 1 and 2. So there is some confusion. You find out. Better about Arab week. Just find out. Huh? Third in part, this matter next week. The State Council will inform the court as to if the post of Anganwadi worker is vacant in any of the Anganwadi centers, namely Godabada put 1 and Godabada put 2. Let him.
One bifurcation for said 1 H. In the Godabada put not a catch.
Say it as on a put. Say it as on a put.
Out instruction on to whether Godabada put to.
अच्छा हुए एमती करो तो कर दें उनसे लाइन था देखो भी then State Council shall apprise the court as to how many Anganwadi centers were created after bifurcation of the original center, namely Godabada put Anganwadi center. সেটা এইগুলো জানা পড়তো next week আসবো third and part করছেন তো yes next Thursday.
Item 21. Is a matter regarding appointment under rehabilitation assistance, my lord. The petitioner is the daughter of the deceased person who died in 22/8/2002, my lord. Since then, my lord, all the documents as required, my lord, has been in Revencha University, my lord. Revencha University was directed by this honorable court in earlier petition to consider her application. Accordingly, Revencha University also has submitted all the documents to the government, my lord. Recently, there has been a development in 2019, for which I have filed an IA, Annexure 4, your lordship may kindly see. IA number 14162 of 2023. There, my lord, government has also repeatedly requested the Director Higher Education to submit the required documents, that is distress certificate from the collector, and all other documents have been complied with. That, my lord, Director has not till date sitting over the matter and not complied, not submitted. Petitioner has been suffering, my lord, since.
You are appearing for?
I'm appearing for Revencha University, my lord.
So why are you not submitting the relevant, the required documents?
So Revencha University has submitted those documents to the Director of Higher Education, and it is now it's the duty of the Director of Higher Education to consider
her application. By government also, my lord, if the lordship may see the document.
I do not. I'm not very much interested to dispose of this application because these are a case of rehabilitation assistance pending since so long, and at this stage only directing the director to forward the. Yeah, rather I'm keeping it pending. You obtain instruction. What happened to this letter? In course of hearing, then counsel for the petitioner draws attention of this court to the letter dated 9/8/2019, copy of which is enclosed as Annexure 4. To to IA number 14162 of 2023, whereby the government has asked the Director of Higher Education to transmit the necessary documents in respect of all the applicants for rehabilitation assistance, including the petitioner.
My name is at serial 9.
The petitioner's name appears at serial 9 of the list of such applicants. Learned State Council shall obtain specific instructions as to what action has been taken by the director on the above letter of the government. List this matter on Ajala Bar, 26th September.
Hopeless. Item 22.
Here is the case. Person was engaged as a Sikha Sayak with way back in 2011 and continuing as such. In 2014, a private person made an allegation that there was some criminal case against the petitioners, private criminal, not no way connected with the employment. That is at annexure, just a turn to annexure 1. The order of engagement is 5/12/2011 as Sikha Sayak. And at present also continuing as such at page 11.
Yes, yes.
This is on 5/12/2011, the engagement order.
Yes.
And these are the conditions. 1 to 9. But an allegation was made at annexure 2 by somebody, a third person, against whom the private dispute is there. And on that basis, some attempt was made to disengage the petitioner because he was in custody for more than 48 hours. Because in that connected that private criminal cases. Criminal cases offense that for nothing to do with the 143, 147, 148, 323, 506. These are the.
So 307 is also there.
307 is not there.
That
is a FIR election. Page 24 also look to that.
24.
Page 24.
Nothing is cutting.
That cottage. In criminal case admitted in subject so and so under section 143, 147, 148, 294, 223, 324, 326. And some sort of clarification was sought for, but your lordship entertained the application and passed an interim order that should be allowed to continue, and that is continuing.
Yes.
But a judgment, you lordship kindly see, the only allegation is that criminal case, nothing else.
What happened to that criminal case?
Pending. Nothing you lordship wanted last time also. Status report. My status report is also that pending.
Then till disposal of the criminal application, let him continue.
It's a good continue. I have we are now in 2024.
It's a junior teacher.
Judgment with junior teacher case, even criminal case. Judgment at division.
I have given that judgment.
Out a judgment. Out a case. Out a judgment the division bench appeal so far the criminal case relating to something which is other than the employment, that is in case of GRS. Let's say look to paragraph 5.
Yes.
Paragraph 4, 5, and 6. In seeking to defend the above order before the Honorable Single Judge, it was contended by the present appellant that the circular dated 21 May 2012 issued by the appellant permitting the disengagement of contractual employee on the ground of misconduct or public inefficiency, even without a hearing. The Honorable Single Judge held that in view of this court rightly that the said circular had no application to the case on hand, since respondent number 1 was taken into custody on the basis of a complaint by a private individual, and the case in which he was imprisoned had nothing to do with his employment whatsoever. The counsel appearing for the appellant is unable to explain to this court why the Honorable Single Judge was wrong in coming to the above conclusion. Para 6. Before the Honorable Single Judge, reliance was sought to be placed on another letter dated 5th December 2012 in terms of which non-performing GRS could be disengaged under section 25 of the Monrega Act 2005. That provision contemplates contravention of a provision of the Act in order to attract penalty. As rightly pointed out by the Single Judge, there is no charge against the respondent number 1, which has violated section 25 of the Act And therefore, that provision had also no application to the present facts of the case. Para 7. And single judge has already observed that it will always be opened by the appellant to take appropriate action depending upon the outcome of the criminal case. The court is informed that the criminal case is still pending. When counsel appearing for the appellant, the report first skip over. So the single judge order is that I've also given, which was upheld. You can also look to that.
No, but I get the point. But here also the same, the criminal case is pending. In case of Sikha Sahaks, you are required to enter into an agreement which contains a clause regarding the criminal thing.
That's exactly my point. So far as the clause, so far the Sikha Sahak is concerned, you can also see that. So far the private dispute and any criminal case which is no way connected with the employment, there is no such violation.
No, that's a different matter. And what I'm saying is that there is a slight difference from this case.
Page 11, sir. The engagement order, the conditions. Terms and conditions, page 11. My engagement order.
Sir. No, there's an agreement you have to sign, na?
So that agreement you also
agreement of Thibagoro clause
say refer
there I have said that probably mere allegation or mere involvement in a criminal case.
More a case I have been now deemed to have been regularized as a junior teacher. Junior, say case junior teacher.
By the time after issue the junior teachers
ଆମ କେସରେ ବର୍ତ୍ତମାନ ଯୋଉ ଅର୍ଡରଟା ଫର୍ମାଲ ଅର୍ଡରଟା କରିବା କଥା କରିନାହାନ୍ତି ଆପଣ ଦେଖନ୍ତୁ ସେଟା ତେଣୁ ଆପଣ କହିଛନ୍ତି ଶିକ୍ଷା ସହାୟକ ଜୁନିୟର ଟିଚର ଇଜ ଟୁ ଡିଫରେଣ୍ଟ ଟର୍ମସ୍ ଯଦି ଆପଣ ଜୁନିୟର ଟିଚର ହିସାବରେ ତାକୁ ଆପଏଣ୍ଟମେଣ୍ଟ କରିଦେଇଛନ୍ତି ତମେ ୟୁ କାଣ୍ଟ ଡୁ ଦ୍ୟାଟ ହି ହାଜ ଟୁ ବି ଗଭର୍ନ ଅଣ୍ଡର ଦ୍ୟାଟ ରୁଲ ସର୍ଭିସ କୋଡ୍ ଆଣ୍ଡ ରୁଲ୍ସ ଏ କେସରେ ସାର୍ ଡିମିଂ ପ୍ରୋଭିଜନ ଅନୁସାରେ ମୋର କେସ୍ ହଉଛି ଯେ ଅଲରେଡି ଜୁନିୟର ଟିଚର ହେଇଯିବା କଥା 3 ବର୍ଷ ପରେ 14 ହେଇଯିବା କଥା. But we are in 24, regular teacher. As per the rule.
No, the thing is, where is that? You have that.
You go to the agreement.
The agreement.
See, agreement.
The engagement shall be cancelled if any fraudulent testimonial is detected in future. And if he or she is criminally proceeded against. Now, criminally, I have interpreted that criminal proceeding is the false fact. Just to put him somebody into trouble, one may lodge an FIR.
This case he has been charge sheeted.
Yes, no, even charge sheet will not do. Yes. Unless he is convicted. If he is convicted, yes, that's a case of involvement in a criminal case. One may not involvement, but what do you say? Conviction in a criminal case. That is different from being in simple involvement. Now, here is a case where the criminal case is just simply pending. So you cannot hold him.
Which has no connection with the employment.
Yeah, that is the second. Primary fact is that the criminal case is pending. Secondly, that whatever the allegations in the criminal case, they are not relatable to his employment. So why should he be debarred from his other
subject to the outcome of
the other benefits? No, even why should this court say subject to the outcome?
Yes, that's it. That's the
So
that is already open for them.
It is for them to find out.
Yes.
What do you say?
Well, there is a what they stand from the.
You want some time? All right, you go through. You go through.
I'll go through, my lord. They stand what we have taken in our counter is that matter. A so-called notice was issued after getting the clarification from the OPEBA authorities. These are not OPEBA authorities, my lord. That in this type of cases, the minimum so-called notice is required to be issued to disengage him from the service. So accordingly, so-called notice was issued.
And that has been negatived by this court in many judgments, including this judgment, my judgment.
So the procedure has been followed, my lord. Now
that procedure, but that the entire thing of removing him only because he is involved in a criminal case has been disapproved by this court. So that cannot be cited again.
And my lord, it is not only as it has been reported in the counter as well as by the headmaster, my lord. It is not only with respect to the involvement in the criminal case, but also for remaining absent.
In this case?
In this case.
Maybe, but he is still continuing by virtue of an interim order.
We have admitted that, my lord, in our counter.
By virtue of the interim order.
By virtue of the interim order.
But here, and one more.
Para number 9, my lord, we have stated so.
Insofar as Sikha Sahak is concerned, since he is to be a teacher, if he is a convict, then that becomes difficult.
That's right.
Sir, you cannot compare him with a Grammar Rozgar Sevak. Because he will be dealing with children. He is dealing with children. So he has to be absolutely above board.
Sir, conviction has automatically, sir.
So that way, I think what you are saying is right. It should be made subject to the result of the criminal case. Simply, bhitur ko napasi ki sati koi chhad dele.
As your lordship pleases, authorize my lord, I may go through that two
Or-
decisions
or-
and this matter will be taken up next week.
Tomorrow,
Next to Brown.
tomorrow,
ଆପଣ ଯୋଉଟା
tomorrow କରିଦବ।
ଟିକେ I have to because even though the counter has been filed since long back.
All right, he normally doesn't take time, but all
हाँ
right.
सर
Third and part?
23 की रखो
Third and part, let's just matter. नहीं, 23 नहीं, 26 करो।
हाँ 24
Third and part, 26 में कितना रहेगा देख लो। 26 को
କପିଟା
इसके बड़ा रंग को डाका।
ମତେ କପି
कितना?
ହଁ ଏଇଟା ଗୋଟେ ପାଇଗଲି
गोटे is the leader. Third and part, let's just matter on 26th.
collector to cause an inquiry after giving opportunity to all the respective parties
Yes.
chance of personal hearing. And on the last occasion, my lord, on the basis of the letter furnished by them, seeking some time. My lord, I had prayed for some time and your lordship had granted me that up to date. My lord. Today in the morning hour also, my lord, I had contacted them. And what they informed me that in the meantime, 2 sittings are already there and where the other parties also appeared. And some more field inquiry is required to be done with respect to that particular issue in order to resolve that particular issue. So accordingly, direction has been issued to the Tahsildar as well as the BDO, both the authorities to get
You want further time?
and need some time.
We'll grant him time.
Lordship, direction is something else. Collector himself has to inquire about the matter.
He is
If your
inquiring.
Lordship peruse the order dated.
So unless the report is before me, how can I say that,
Because,
Mr. Mishra, if the order is not before me, how can I say that he is not inquiring? Let the report come. जी खाली inquiry करिए निजे बोले अपन अन्य काम पछाड़िए नहीं.
Because there are 3 inquiry report is there. For that reason, your Lordship directed.
Anyway, I directed the collector.
He is aware, my lord.
It is up to the collector. He will be taking a risk if he will not.
That's because at that time, your Lordship directed sub-collector.
So he wants some time. Let us give him some time. That's all. 2 weeks time देंगे अपन.
3
Last
weeks.
chance they
Check
can
out
last time.
Yes, I admit that, my lord. But
Because I am out of service, my lord, being eligible for that. reason.
2016 matter ଆଉ 2 ସପ୍ତାହ କାହିଁ ବେକାର ଆପଣ ମୁଁ କିଛି ବୁଝିପାରୁନି ଏଥିରେ ଏ ସବୁଥିରେ ସେମିତି ଲେଖାଯାଏ ସବୁଥିରେ ଇଏ କରାଯାଏ this country has to run sir we are not writing on a clean slate ଏତେ rigid ହେଲା ହବ though in the previous order though on the last occasion it was made clear that no further time shall be granted yet today Learned State Council requests for 3 weeks time further time on the ground that the inquiry, which is presently in progress, has not been able to be concluded because necessary instructions have been issued by the collector to the Tahsildar to conduct field inquiry. Stop. Considering the above submission, this court observes that ends of justice would be best served if one more opportunity is granted to the collector to conclude the inquiry. Release this matter on 3rd October. On which date the report of the collector should be filed before this court. Yes.
free copy of this may be so.
Free copy of this order be supplied to the State Council for compliance.
Item 25.
Somebody had made a prayer in the morning.
24 ଟା କଣ ଆଜି?
25 ଟା adjourn ହେଇଯାଇଛି? 24. Okay.
connected read ଟା ଅଛି ତା ସାଙ୍ଗରେ
25. କଣ connected read?
In this connected read in this present read petition, I am the intervener, your lordship. And
allowed?
intervener allowed. And I was implicated in party.
No, internal well has not been allowed.
That's a different matter, sir.
No, no. This is a similar matter, your lordship, where the entire selection process, creation of Anganwadi center has been challenged, your lordship.
All right. So when do you want?
In that case, counter and rejoinder has not been filed. Counter rejoinder and I have imputed the present petitioner here, their opposite part number 6, and he has filed certificate saying that the matter has never reported this honorable.
With respect to the Anganwadi area, that the BLCC has already decided that is also annexure 4 and I'll show you.
Anyway, if he says that there is a connected matter, let us bring that matter. If it is connected, well and good. If it is not connected, we'll take acting.
I think this intervention
Regional
petition has not
counter
been,
particularly मिल जाए.
intervention petition has not been allowed, I think.
Your lordship intervention petition allowed.
Order director.
Yes. 3-2 में intervention allowed लिखा है जी हमारा.
No. Order director.
No.
In the
Intervention has not been allowed.
It has not been allowed. Additional government order was directed to file the instruction that was sought for earlier by your intake of an affidavit.
Intervention allowed लिखा है.
No, no, not allowed.
All right, release this matter.
Copy also he has not solved.
All right, release this matter next week. Along with WPC number.
WPC number 20375 of 2016.
20375 of 2016. A copy of the intervention application be served upon learned counsel for the petitioner in the meantime.
Counter and rejoinder with a file case.
Intervention allow हो देखिए.
Item 26.
That will be problem.
Next week, next Thursday. Yes, item 26.
Counter has not yet been filed.
Yes, in Aholia Gode, my lord. Today, my lord, also, my lord, had contacted them. Actually, it says in all the cases, here up to 17, this all the CDPOs, they are actually they have given the tax for the Subhadra Yojana. So ଆମେ ତାଙ୍କୁ ସବୁ ରେଡି କରିକି ତାଙ୍କୁ ଏଠି ଦେଇ ସାରିକି ଡକେଇଥିଲୁ ବି କିନ୍ତୁ
Release this matter on 26th September as paid for by the state council.
Yes.
Counter will be filed in the meantime, interim order to continue.
Item 27.
The advertisement was made by the annexure 1 for the engagement of.
Counter file ହେଇଯାଇଛି?
ନା ଏଥିରେ ସାର୍ ସେଇ ଆମେ ପାରାବେଜ କମେଣ୍ଟ ରିସିଭ କରିସାରିଛୁ. We need some time.
File a counter.
26th ରହିବ.
Learned State Council submits that he has received the Paravez comments and would file a counter soon. Is this matter on 26th September? Counter be filed in the meantime.
Yes.
Item 28.
बड़ा कुकु आपके पानी आने. Yes. Yes, Mr. Author.
Lordships. Lordships, just a small written note for reference.
Not so small.
It's only the date chart which has been elaborated.
No, but on the last occasion, there was a point with regard to the maintainability.
That's the facade which both the state and the opposite parties are creating, trying to look at it maintainability. But actually, it's a point of jurisdiction, in the sense that the state has done something. The impugn order is totally without jurisdiction, and the connivance with both the parties will be seen with the facts. Oh, even a point of jurisdiction, let me put the facts.
Yes.
Then your lordships.
No, I'm not stopping you.
Yes.
You can
Then
argue.
your lordships will actually understand that this issue should not have crept up at all. What has happened should not have happened. It has happened, and in fact, we have been taken a point of legal malice in this case. So against the state.
Yes.
So your lordships, just to put the facts straight, your lordships, I am Utkal Sini Chamber of Commerce. And your lordships, this has jurisdiction whole of Orissa. May I just take your lordships a relevant page?
Yes.
That would be page annexure 1 to 3. Relevant page will be 32 onwards.
32.
So your lordships will look at clause 3. To promote, protect, safeguard the interest of cinema industry as large producers, exhibitors, and distributors engage in the business of production, screening, and distributions of features in the state of Odisha. So this was a body which was formed with jurisdiction from all over the entire state. And your lordships will then look at page number 34, which is rules and regulations of the. It was established in 1st January 1992. Jurisdiction shall be the whole of state of Odisha. Then you'll actually look at the executive committee. The executive committee shall consist of members as may be decided by the general body of society, and the management of society shall be vested in the executive committee duly elected by the majority members of general body, which shall also elect by direct election the president, vice president, secretary, assistant secretary, and treasurer for the administration society. The executive committee shall meet once a month, and general body shall meet according to the resolution of executives. Then your lordships will look at page 35, secretary. The secretary shall be responsible to the governing of proper discharge and execution of orders and resolutions. Only to that extent, your lordships. Now, your lordships, this body initially, when was actually registered, this shows at page 32 itself, it was registered with Vasant Kumar Naik as the president and B.K. Mahanti as the vice president, P.K. Mahanti as the secretary. That's there at page 32. Now, your lordships, this was the situation. Now, this particular society has 3 wings. One of the wings is before that, your lordships, may I just take your lordships to Annexure 6, page 45, which is actually important. This is the registration which was issued to us. It has a registration number, which will have a bearing when subsequently I show the impugned order. 12663 by 409 by 1993-94, dated 5/10/2000, 1993. Issued by additional registrar of
कोड 93 টা কোড লেখা 5 অক্টোবর 1993 রাইট yes
তো ডাইরেক্টলি ওটা পড়ি পারেনি এটা লেখি
আস্তে কোড সেটা করতেন
হ্যাঁ
সেটা করতেন মতে ভারি খারাপ লাগে নো আজ আন ওড়িয়া মতে কষ্ট লাগে
বহুত গাড়ি খাউଥିଲି মানে not that I can't read, I can, but not confident.
ମୁଁ ବି ଓଡିଆ ପଢିନି you know that
You write so I'm aware of that.
ସେଇଥିପାଇଁ କହିଲେ ଆସ୍ତେ କୁହ କାଲି କି ଶୁଣିଦବ ବାହାର ଲୋକ କିଏ
ସେ ସବୁ ଜାଣିଛନ୍ତି ବା I was pulled once in Justice Sarangi's court.
so next time you will say that I have managed to read in my court.
No, I can read, not that I can't read, but not fluently as English. That's the whole problem.
1993 तो हला 1993 5th October 1993
And it's issued by additional registrar of society. Now, this is very important because these issues will come up. Now, your lordships.
no is there a problem here? Additional registrar, he may be in charge.
Yeah, no. I'm not even on that. What I mean to say is that the grounds that they have taken, for that reason, I'm showing this.
All right.
And your lordship, this body, as I said, had 3 wings. So there was a production wing. This is called Sini Chamber of Commerce Production Section, which later was called as Odisha Film Producers Association. I mean, that's there in the date chart also. And your lordships will look at Annexure 8, page 48. Now, that was the up-to-date list of members.
Yes.
As on 1/1/2023. Now, your lordships, what happens is 2 people. One of them is Sanjay Kumar Naik and one is N.G. Reddy. What they do is they go and file a representation before the registrar society, saying that this very registration certificate should be cancelled, raising the jurisdiction under 12D. He makes a representation there. In the representation, he does not write that he is the president or the secretary, because he was not. But he has filed a fraudulent document. He's made a resolution of some 5-6 members and that I am the president. But in the representation, he does not post. And which, your lordships will look at that how they're paid hot and cold in the whole thing. Now, to that extent, your lordships may look at Annexure 11 and first Annexure 12. Page 63.
This is that representation.
Yes. Now, this we got in the RTI. Now, and also because it was filed before the High Court. this is the complaint for cancellation of registration number so and so, Utkal Sini Chamber of Commerce. And your lordship will see at page 65, the whole of 12D is raised. And the last page 67, he makes the prayer that you call for record, make the investigations. And there he writes Sanjay Kumar Naik and Reddy. They don't pose as president or secretary then, because they're not. But a fraudulent document has been filed, which no answer they've given here, which is Annexure 11,
Copy the minutes of the meeting.
page 61.
Yes.
Where they say the members present today further unanimously have elected the following members and to take legal consultant go ahead with the authorities in court or law for fraud. That's just no, that's just page 60, second paragraph. On the consent of all members present, it is unanimously decided that Sri Sanjay Kumar Naik, Basant Kwan Entertainment shall preside over the today's meeting, and N.K. Reddy, no, secretary. So anyways, your lordships, that being so, this Sanjay Kumar Naik, after filing a representative, files a writ application. The writ application, no notice is gone. He says that this so-and-so representation is there, they're not taking, please dispose it of. And also takes an order from the court that there should be no elections. So 12B applications should be disposed of and no representation. Now that order, your lordships, I want to show. That would be annexure 14, page 130.
Yes.
130.
Yes.
It's one-sided order. Para 4, the complaint by the Annexure 3 series made before the opposite party number 1 be considered and disposed of in accordance with law 3 weeks on the date of receipt. The petition is directed to produce the certified copy before the opposite party for compliance. This is order number 1, your lordships. Till a decision under Annexure 3 is taken, no election to the executive committee of Utkal Sini Chambers of Commerce shall be undertaken. That means, till election is not concerned, the members who are there, the office bearers are there, as it is, they stay. Now what happens is, your lordships, under Annexure 15, page 132, notice is issued. Sini Chamber of Commerce. I'll just read the first paragraph. With reference to the subject award, this for information that the present office bearers of Utkal Sini Chamber of Commerce at so and so and so, that the additional district magistrate general has fixed a date for hearing as per the order of the Honorable Orissa High Court at 3 p.m. And they do say that you produce all the supporting document as per the Kumar Naik. Now what happens is, he actually has not made the office bearers of Utkal Sini party here. So wrong notices go. And therefore, these people appear. The first few people named people appear. And then they say that, please kindly actually issue notice to the office bearers. And that order, your lordships will find at Annexure 15, page 1. No. Your lordships find Annexure 16, page 153.
So this is a reply.
In that reply, what they did is that small production unit. See, production unit ko nahi ke sabu gondor chalchi. See, production unit ra member ko send party kar de notice diya kare de. So they appear. They said that we are not, because you are talking about cancellation of Utkal Sini's registration. We can't be answerable. The office bearers will be answerable. So they file an objection at page 156 at para 9. They say,
yes,
that in view of the above ground, The person noticed by a good office are not authorized persons of UCC, save and except that they are only members of the said association, and such they are not able to produce a document used as required by a good office or give any effective reply to allegation mentioned in the complaint. So that's when the authorities come to know that the correct notices have not gone. Under Annexure 17, page 158, finally the issue notice. We Lordships will find the last portion, page 159. Last few lines, since. Since the office bearers of UCC were not present, no decision could be taken in the matter relating to the organization. The office bearers of UCC shall be noticed to be present before the ADM, additional registrar of societies, and of all aforesaid documents relating to society for inspection. The deputy collector will be directed to issue notice to office bearers and seek permissions from the IGR regarding blacklisting of OFPA. Now, this is very important. That means the authorities are well aware of what's happening factually. And your Lordships, thereafter, under Annexure 90, some documents are produced. 161.
Yes.
The proceeding is pending. Nothing has happened. And your Lordships, the impugn order is then issued under Annexure 162. A fresh, I don't know what.
Annexure?
162.
Certificate of registration.
Yes. Now, what is this? This is what you're saying. This certificate, when I will compare it with the provision of law, your Lordships will find it does not fall anywhere. It's a very innovative way.
No, you have to repeat here because that dispute is pending.
The dispute is pending.
So this certificate has been issued.
This, and I'll make your Lordships read that certificate. It's very interesting. Page 162.
Yes.
Certificate of Registration Society, Form 1. There's a relevance because each section has its own form. Under Rule 7.2, same registration number, your Lordships will see. No, different registration number for 2023-24, issued against a old registration number of additional register of societies cut off.
So this is a fresh registration.
We do not know where it falls. That's the point.
It purports to be a fresh registration.
Yes, your Lordship. And same name also used against the same registration, and that has cancellation proceeding is pending. And this is issued. Both of them, the opposite parties, neither the state has produced before the court under whose application or under which powers did you do what you did? Like, where did this come from? And strangely, your Lordships will see who now is posing to be the president. Now, Lordships will see page 169, because the memorandum of association, everything, rules, regulation, everything has to be annexed. Page 169.
169.
Sanjay Kumar Naik, bottom. Sanjay Kumar Naik takes an order from the court. Please dispose my 12D application. Don't have the election. You yourself in the writ have not posed to be the president. In the representation, no. You yourself in your application, different office bearers were called to reply. How did you become the president? And the authorities, knowing very well of what is happening, how did you act upon it? Connivance is tilted. Now, this being so, we make a representation to them. How did this come in 12D proceeding is there? They say, no, you go under section 11. It's an interstate dispute. I say, no, it's not an interstate dispute. We are questioning your authority. You are sitting over 12D. You're looking at the validity of my registration. How and under which provision of law you're doing this? Now, your Lordships, let me show the contradictory stance which both of them have taken as far as the issue. And where is
what happened to that representation? They said, where is that reply?
Interstate dispute.
Where is that reply? Where is that reply?
Yes, your Lordships.
I think Annexure 23.
23.
I am directed to say the registrar of the societies has no scope to intervene, regulate the internal conflict as per the provisions made under Section 11A of the Societies Amendment Act. All right.
Yes. My contention here is you could not have said that because you are sitting over the matter. You are definitely acting in hands and gloves. And I will show because the provisions don't permit you to issue that. Now your Lordships will see. We'll look at the, yes, your Lordships. First is, what is the nature of the certificate vis-a-vis the provisions I'll show you.
Registration.
These rules may not be available in the book.
Society's registration act.
This rules is not available in the book.
All right, all right.
It was act. 24.
These are the society's registration rules 2023. You are referring to that.
And also the act, Your Lordship.
Act about society's registration act. Let him bring up.
Now, Your Lordship, look at this was issued under Form A, Rule 7.2. Now, Lordship, let me read what is Rule 7.2. Registration process and certificate of registration. Upon receipt of memorandum of association along with certified copy of rules and regulations society and documents are submitted by the registrar for reference to effect registration in pursuance of the provision act shall be verified. The certificate of registration of society shall be issued Form 1 under the hand and seal of the registrar or additional registrar as the case may be. The entire process of registration issue that is done electronically. Now, Your Lordship will look at this. This Rule 8. Rule 8 talks about renewal. Then Your Lordship will look at Rule 9. Amendment. Now, why I am comparing them? For each situation, there is a provision. So, 7 is always for a fresh registration, something newly registered, newly body is registered. Because one of the contention they have taken, the state has taken, no, it was issued by additional registrar prior to coming of the of these rules and the amendment in the act, and therefore we are re-registration. No provision of re-registration. It at best can be an amendment. If you are saying that the jurisdiction has to go to entire state of Odisha, we'll make Your Lordships go through that. At best, an amendment. They have taken a plea. No, there was an expiry. Therefore, we wanted it to be renewed. So then renewal is there. So 7 cannot come into picture. 7 means a new body is being registered. Now, Your Lordship will look at it has been issued under the same name. That also has a bar under the Act, which is 3A. No society shall be registered by a name which in the opinion of the registered society is undesirable, being a name identical with or which in the opinion of the registered society so nearly resembles a name of which any other existing society has been previously registered under this Act. A valid registration is there. So this is definitely not the area where definitely not the provision under which you can exercise your powers. And admittedly, you've done it under that face of. Now, Your Lordships will look at, and admittedly, 12D proceeding is there. It's a farce. One hand, you are saying, I'm looking at the invalidity of it. And the other hand, you are, I don't know what you are doing with this body and what you have issued. And Your Lordships will look at now the contradictory stand which both parties have taken. Now, the private opposite parties, that is 4 and 6 and 12, 13. And interestingly, the two parties who did not have appeared and now said that we don't want to contest. I mean, they are not helping them anymore, though they are also named in the memorandum of association. Now, what they have done is, Your Lordships may kindly look at the running page 228. This is a counter affidavit private opposite parties.
Yes.
2 paragraphs only. Your Lordships will see VI.
Yes.
It is an inescapable position. Through RTI also we had obtained, which said that registration is still valid. It is an inescapable position that as per the RTI information appear in Annexure 22 series, page so-and-so, read with so-and-so impugned order, there is no cancellation of the earlier registration. But in accordance with Rule 2021 rules, which is actually 23, no 20, the same was re-registered only.
There was an amendment in 2021.
That's in the Act.
That's in the Act, yes. Probably they're referring to that.
Rules publication.
Where that new forum was created, 11A.
Gotcha. Many other provisions also have been. On such count, there being a disputed question of fact on the office bearer, they say. But your lordships, I have shown, you yourself have taken the order from the court and have not disposed this application. How did you become the office bearer? It's to you to be explained. And how did you, sitting over the matter, is allowing this mockery to happen? Is to you to be explained. Now your lordship, look at para 9. Is how they explain. Okay, fine. Even if you're office bearer, produce that application that you filed before the authorities. None of them have produced. Because any provision ta lekha hai tu. Para 9, that much reference has been made to Rule 7 of 2023 alleging non-compliance. The rule could not have been read alone, but is required to be read along with Section 3 of the amended in 2021. The registration issued in 1993 remained valid for 5 years. And after 2021 amended, had expired and no longer remain valid. So their story is that this registration has expired. In such circumstance, the opposite party sought to revive the society by obtaining fresh registration under Annexure 20 against the old registration in accordance with amended 3A of the Act. So what they are saying is, it expired for you, re-registration, basically renewal. Now your lordship will look at the provision. Section 3.
Section 3.
The proviso here is the 2021 amendment, Odisha amendment. A certificate of registration issued under subsection 1, 2 term age poduchi, shall remain valid for 5 years from the date of issue. Aguru validity period not thila. If this book is not then maybe it will be little difficult. Because it's an Odisha amendment.
Anyway, we'll get it.
Thank you.
Yes, Odisha amendment.
A certificate of registration issued under subsection 1 shall remain valid for 5 years from date of issue. This was a change of circumstance. Aguru, it did not have a validity period, now it has. Provided that a society registered under this Act before the commencement of Society Registration Amendment Act 2021 shall remain in force for 5 years from the date of commencement.
So from 21 to 5 years means 2026.
So it had not expired. So the story of expiry is also false. Now, your lordships, when a particular registration expires,
Have you seen the Gazette notification of this? Better check up, because these things are very dicey, could be very dicey. You obtain the Gazette notification.
We will do that.
Yeah, you can get it from the net also. Go to the concerned department.
Ajikali government rules, regulation, border luchi.
No, net
net in a particular service matter, literally I press a law department concerned department because they knew virus challenge.
Normally all the Gazette notifications are uploaded.
But this is something seriously we had raised, I think.
Why I'm saying is this, because I'm very sorry to say, but sometimes it becomes very difficult to rely upon these books.
We had a trouble. OLR jo bohi aise, some other provisions showing, these local acts are showing other provisions. And that problem, in fact, occurred in one of the arguments which had happened recently in the Chief Justice Court. And then after a lot of search, when we finally found that what the correct provisions are.
There may not be any incongruity or discrepancy, but it is always better to check it.
There was, in fact. There was.
Yes.
So we are actually facing this trouble every day. Especially with the new rules which are coming up on these short service 309 rules.
309 rules. Anyway, let us accept it for the present.
Your lordships,
So what you want to say is the point is taken. You mean to say that even assuming that it has expired, then it will be further valid for 5 years, which takes it to 2026.
So the story, because the story that they have stated, it has expired, and therefore the re-registration. The story is false on the face of these facts, and also when a particular registration expires, there is a procedure for it. Section 3C says, 3C, the registrar of society shall publish in the official gazette The name of the society whose validity of certificate of registration has expired. No such publication. So your story is false. Not only this, you'll also look at 3B clause 4. আমি annexure 24 agent notification টা দেই।
Same as stuff. Doesn't matter. Just to be sure that it is the same thing, which is reproduced in this book.
We are every day facing that.
No, you have to.
Not reliable.
You have to go to the Gazette. Yes, so it says that if he is satisfied that any of the grounds mentioned in section 12D exists in respect thereof, the refusal of
The registered society may refuse to renew the certificate of registration if it is satisfied that any of the grounds mentioned in 12D exist in respect after giving opportunity. Not when 12D is itself pending. I would take it 12D itself pending. You're looking at the objection. Then where is the question of you renewing it? Your hands are tied. Unless you don't dispose that, you will not do it. And there exactly the parties have been called upon to answer that.
yes.
So this is all there before them. So once is their story, factually and legally is actually incorrect. It's a story just made for the court. Now, but what's the story of the state government is far more interesting.
Now you have to refer to this again.
Yes, sir.
We'll
No,
continue after to continue till 1 o'clock, and thereafter we'll take it up on some other day, making it parted for Mr. Mishra to reply, provided you complete.
That's it. I may take
No, doesn't matter. You will take your time.
last. Yes.
You can take time as long as you want. No, it doesn't matter.
Should look at state counter. I do not have the running page.
It doesn't matter. Paragraph kontu?
Para 4.
Yes.
Page 2. Even other paragraphs are just show para 4.
Yes. That in reply to the government.
That is by the government para 15, or that it is humbly submitted. It is not a registration, rather a fresh registration by Utkal Senior Commerce. So they don't say renewal. With Register of Society as required to be done under the amendment made to the Society Registration Act, amended in the year 2021. The new amendment as per section 3(2) of the Registration 2023 provides a society to be registered. Actually, এটা ভুল লেখুছেন মানে যে রুলটা করে রেফার করছেন আমি show that. Provides a society to be registered with the registrar of society for having statewide jurisdiction. Then you'll also look at para 6 and 8. That in reply to averment made in para 17 of the writ petition, it is most humbly submitted since there is no communication from the office stating therein that the Utkal Senior Chamber of Commerce has been re-registered rather it is stated from the above paragraph. The society registered district level has been registered state level by enhancing its jurisdiction under section 3(2) of the Society Registration Act. That means it is only an amendment. If you buy a story, but you'll also say I have already shown that jurisdiction pura Odisha thila. That also they have not checked before writing this. Then para 8, you'll also same thing. Para 8, they've repeated the same thing. Then para 9D. Page 4 of that counter. That in reply to the averment made in para 22D of the report, most humbly submitted that the society is a re-registered is wrong and misleading. 80, they say re-registered, then no register, misleading. Rather, the same society which was registered at additional registered societies, Cuttack, had applied for registration with the registered society for having its wide jurisdiction required under provision of society registration. But already they had wide jurisdiction before the whole state of Odisha. So factually you are incorrect. You didn't check the records and you just did what you wanted to do. Now the question is, it is of a provision that's a Gadbad lecture. We also got very surprised. Then we realized the provision is actually in the rules. What they're actually referring to is rule. Now the rule here, let's just look at rule 3. So set up section 3, section 3 lekhi chal chal. The rule. The registrar shall have the power of superintending the implementation of all work relating to registration of society in the state and may issue guideline instructions time to time not inconsistent with the Provision Act for efficient and prompt delivery of services and redressal of grievances of the public in the matter of registration societies. The registrars have the jurisdiction to register society where it is registered office is situated in any part of the state, but its operations, area of operation activity shall extend to the whole of state or to more than one district. Additional registrar shall appointed in respect of a district or more than one district shall function under the direct control of the registrar and shall have jurisdiction to register society where its registered office is to be situated in any part of that district or districts, but the area of operation activity shall be extended to whole limits of the district. So district, this is what introduced. So this is basically an administrative jurisdiction. This provision is not saying that the existing registrations become invalid. Rather, the proviso in section 3 is saying you are valid for all purposes to go. So all that you combined reading is understood. The renewal hub. The amendment is required. These are the bodies accordingly we will approach. Admittedly, we were already there in whole of state of Odisha. So factually, there was no cause of action that we had to go to state of Odisha. We were already there. So factually, you are wrong. You have not checked it up. Especially when you are already sitting on a 12D proceeding. And this is not which is conferring your power to do what you did. This is only an administrative distribution of power between you. It's not saying that because this is there, so you call for all the registrations as if in so moto do what you want to do. That's not the case. Especially, you can't use this to justify your action under section 7. Because this at best will be 9. What a body exists, even if jurisdiction is small, if he wants to expand, it's an amendment. Expansion. So you should have issued Form 3, not Form 1. So when that argument of yours falls, and you are saying contradictory to what they are saying, none of you are producing what did you find there. This person, opposite party, on his own pleading, has a 12D proceeding there and has taken a stay of everything. But then suddenly becomes a president and you act upon it. And you can't say your left hand did not know what the right hand was doing. Obviously, there's connivance. And then, Your Lordship, maybe I'll continue next time. We will show legal malice. We have some more arguments on fraud and legal malice.
Yes. If I believe your case, you have completed almost, you touched all the points.
This preliminary submission is only to say that this is not an interstate disputes really. Here, what is questioned is, what is your jurisdiction? What did state do? State can't do what it did. That's the whole thing. Because you weren't knowing of everything.
Well, yes, Mr. Mishra will take it up next week. Heard in part, place this matter next week. Later, hey, next week means it will come on next Thursday. Yes. So
DP of Pipili. Recently, she had joined. On 26th matter, this matter will be taken.
Is this matter on
We'll file the
26th,
counter.
26th September, as requested by London State Council? Yes.
30.
The cause list indicates they have filed counter, but I have not got a copy.
Let a copy of the counter filed by the
There are more eight signs.
state. No, a copy of the counter filed by the state is served upon Land Counsel for the petitioner in court, who wants some time to go through the same. And to file a rejoinder if need be. List this matter
3rd October.
on 3rd October.
Interim order to continue.
It's in order to continue.
Item 31.
In item number 31, my lord, today I have also received a communication from the CDPO that she needs some time. But
Alright.
for the first time, my lord, it has been, notice has been.
So when do you want?
On 26th, ma'am.
List this matter on 26th September as requested by London State Council. Yes. Pathar.
So item number 11.
11.
No, let me.
If you lordship look to
Because
the
passed over, it is a parted matter, that's why I'm taking up, otherwise. Normal passover, normally I don't take, but this is a parted matter and a senior counsel is there, he is requesting.
Yeah, good. I think he will take time. Response.
That's nice.
Serial number 11. 11th.
Yes.
Counter agent file. Your lordship heard this matter in election show. Your lordship wanted that they should file affidavit in response to a resolution policy decision dated 22/4/97.
Oh, take over that primary school.
Yes.
Yes.
So, my lord,
I have also given a copy of the
No,
judgment.
you have to come up with a definite stand.
my lord, apart from that, recently one more judgment also, my lord, it has been passed. The same line, and I have received a copy today, my lord. It may be taken up.
Next week then. Next week होगा नहीं?
Sir, it is I have been over.
More on एक
अच्छा।
25 दिन।
कर दो।
24, 25, 23 देते हैं।
हाँ? कब
26.
26th.
26th.
London State Council submits that recently this court has passed, a coordinate bench of this court, coordinate bench or
Yes, sir.
division bench?
No,
Coordinate bench of this
coordinate
court has passed a
bench.
judgment relating to the same matter. And therefore the matter may be adjourned to permit him to go through the same. List this matter on 26th September.
Yes.
So item number 14.
14.
My lord, in this case, on the last occasion, I was directed to verify.
Tabular list of candidates and the marks secured by them.
Yes.
No, you were to give that.
No, I have already prepared. He has also prepared.
My lord, today
Same.
also, I have also. So just
On the
now,
basis of that,
because
1, 2,
just
3.
now, my lord, they prepared it and they have communicated to me, my lord, through WhatsApp. So I have prepared a copy in this way, my lord, without any memo. My lord, there we have admitted that with respect to the petitioner number 1, petitioner number
लिखा है तो नाम वाला लिखा है कि नहीं
Actually, serial करते petitioner sir.
More serial number, sir.
एक मिनट विजय कुमार सामंत is petitioner number 1.
Yes, ma'am.
2 and 3 are not placed in the revised merit list.
No. Because, Lordship, may appreciate that, my lord. The category we have indicated, thereafter, my lord, the mark secured by the petitioner, that is the first column. Then the cut-off mark of the respective category as per the revenue district merit list. There, my lord, the petitioner had secured less. I am giving one example, my lord, petitioner number 1. Now, my lord, after Anup Sahu case, the revised list part, it has been produced before Lordship through rejoinder. There, my lord, the cut-off mark is now 46.14.
So he qualifies?
So that is what, my lord, I am submitting. Petitioner number 1, 4, and 5. They have actually secured more mark now.
उल्टा कथा कहलो 1, 2, 3 ना
ना sir, 2, 3 कर ना नहीं.
2, 3 are not placed in the revised list. Yes.
1, 4, and 5. My lord, they have secured more mark in comparison to the person of the last person of their own category. After that, revised list of it has prepared, my lord, on the basis of the as per the decision of this honorable court in Arun Sahu case.
चंद्रमणि जना केस अनुसार कर देइथिले कि अरुण साहू केस रे सेटा पैसे तो बेसिस रे वर्तमान एई 3 जण ता जे पाइचे अनुप साहू ताटो अधिकार कटअप मार्क अधिकार
खाली किंतु 2 और 3 पाइबेन
2 3 लेक नेचुरल सी कोचन रे बेता कर बटे
नहीं हमें देइछु
ଦେଇଛନ୍ତି sir.
ମାର୍କ ଦେଇଛୁ ତାଙ୍କର
So,
ମାନଙ୍କର
should we close it or should we keep it to another date?
Let's close.
ବହୁତ judgment ହେଇଗଲାଣି ଥାଉ।
Practically, was that, but in view of their own.
ଅନ୍ୟ matter ଗୁଡା ରହିଯାଇଛି। ଡାକିବାରେ କିଛି ନାହିଁ ଯେ ଟିକେ
ଠିକ ଅଛି, ଠିକ ଅଛି।
ଅନ୍ୟ matter ମାନେ ଅନ୍ୟମାନେ wait କରିଛନ୍ତି। I'll just keep it to one more day.
Sir.
On that day, maybe in the court.
23rd.
Aye?
23rd.
ହଁ ଅଛି ଦେଖିଲ। Learned the counsel for both parties file the tabular list of the candidates and the marks secured by them can be kept on record. List this matter on 23rd.
And also indicate that, so for the petition number 1.
No, I'm not indicating anything today. It will be better.
Yes.
Let it be on record so that on 23rd, list this matter on 23rd. But further arguments in part available. Yes.
Item number 32.
And we can also notice already sufficient manner. And the petitioner is the wife filed PRPC transfer from Jashpur family court.
Notice is sufficient.
My lord. Endorsement is there.
AD is returned with the signature of one Manasidas instead of addressee and relation of recipient to the addressee. No, the petitioner herself has received the notice.
Petition is the Pavasi Dr. Maya. Manasidas she has received.
How key Manasidas, we do not know the relationship.
My lord.
So how can we treat it? You take notice again. Or we will do it, you serve a copy, the police will serve it.
My lord, also.
Yes. Let an extra copy of the transfer application be served upon the state council, who shall ensure that the same is served upon the opposite party through the IAC of the concerned police station, indicating that the matter shall be taken up for hearing on 3rd October. Place this matter on 3rd October.
Interim to continue.
In order to continue.
33.
Fresh mediation report.
Please, madam. There are two sets of application, lordship. I am appearing on behalf of the wife who has sought for the.
The report of the mediator indicates that the mediation between the parties has failed.
Yes, madam.
Yes.
I am appearing on behalf of the wife who is in petitioner in TRP civil number 3 of 2024. Wherein she has filed.
In the first case, you are the opposite party.
Yes, madam.
And in the second case, you are the petitioner.
Yes, madam.
You wanted to be transferred from which case, which place to which place?
Lord, from Bhubaneswar to Jagatsinghpur. The case.
And you wanted to be transferred from Jagatsinghpur to Bhubaneswar?
Yes, madam.
A criminal case filed on 125 CRPC filed by the wife before the Bhubaneswar court. I seek transfer to Jagatsinghpur, where my application on section 9 is pending. There, my lord, evidence has started. She has filed already his written statement. My evidence from the side of the husband has already been closed. She has participated there, and proceeding because of stay order before this it has stayed. Now, so far as the 125 application filed by the wife of Bhubaneswar is concerned, their interim order was passed to pay the interim maintenance. I am also going on paying. And so far as the 125 proceeding is concerned, Lord, she has also admitted that there is a minor child who is prosecuting study at Paradip. And the husband place of posting, who is a loco pilot, also his place of posting at Paradip. Therefore, and so far as the parents' house of the wife is concerned, she has also disclosed in their petition that is also at Jagatsinghpur. Now, showing her address at Bhubaneswar, she has filed 125 applications before the court at Bhubaneswar.
My lord.
Because of the changed circumstances, when the wife has already attended there and evidence from the side of the husband has already completed, it is therefore desirable to complete there both the cases 125 and section 9.
As the husband has not complied to the order passed by this honorable court, the interim order stands vacated, and in the 125 proceeding, the evidence has also been started, lordship, in the 125 proceeding. And so far as the address cited by my lord and senior is concerned, I am presently residing at Bhubaneswar. First of all, I have filed an application under section 125 of CRPC before the Learned Court of Justice Family Court to Bhubaneswar. Subsequently, I have also filed a complaint case under section 156 of CRPC, and the FIR was subsequently registered. That is in the month of August, and subsequently in the fag end of the 2023, they have filed an application under section 9 of the Hindu Marriage Act, when their guardianship application was he has withdrawn, which was filed before the Honorable Court of District of Jagatsinghpur. After withdrawal of the said application, they have filed an application under section 9. And so far as the study of the child is concerned, now he is residing with his mother at Bhubaneswar. He has also, her mother, the petitioner, has also filed an application before the principal of that school to transfer that for the child from KV Jagat Paradip to Bhubaneswar. But as because the husband has filed an grievance before the concerned principal, they are not ventilating the grievance of the wife and they are not also granting the transfer certificate. He is attending the school, but he is now residing with his mother at Bhubaneswar. Even the summons are sufficient at Bhubaneswar, so far as the TRP CRL is concerned. No, I have never resided at Paradip because there is threat to my life. ମୁଁ ଯୋଉଠି ବି ରହୁଛି ସେ ଘର ଓନର କୁ ଯାଇକି ତାଙ୍କୁ ମୋ ବିରୁଦ୍ଧରେ ଏପଟ ସେପଟ କଥା କହୁଛନ୍ତି. So right now I am residing with my brother at Bhubaneswar. In both the address summons have been sufficient. The 120 proceeding evidence have also been laid down by the wife. So my humble submission, as because the child and the present petitioner is residing at Bhubaneswar, so the matter may be transferred to Bhubaneswar.
Sir, both the applications stands rejected. Yes, I'll pass the detail order. Both applications rejected. Yes.
So far, Miller,
I find no merit in either of the applications. Rejected.
one thing may I say, so far as area is concerned, but
I have
already paid, not that I am not going.
Yes.
So far the little child is concerned.
Evidence are you disputing that evidence has not started?
No, I am not at all disputing.
So once evidence has started, the matter has progressed. Order to transfer kori kichh nahi. ठीक है. ना visitor रहो. उभय कैसे visitor रहो.
Yes.
34.
Yes.
Item 34.
Be permitted to submit on behalf of this matter.
Yes. Yes.
My lord, the correct address has been found and the requisites will be filed within Tuesday, my lord.
Learned counsel for the petitioner submits that she has ascertained the correct address of the opposite party and undertakes to file the requisites as directed by Tuesday.
Yes.
Requisites be filed, fixing a short returnable date. List this matter on
4th October.
24th October, interim order to continue.
Published.
Item 35.
I am appearing for the opposite party. In this matter, hearing has been concluded and judgment result.
No, what happened is actually, you did you not inform on the next date that you mentioned that you will inform Mr. Das?
ନା ମୁଁ ତ କହିନି
କହିବା ଉଚିତ ସେ ଆପଣ କହିଲେ ନା ସକାଳେ ମେନସନ କଲା ବେଳକୁ
ମୁଁ କହିଥିଲି ତାକୁ anyway he is not informed.
So on that occasion we heard about and the next morning you made
second actually
no ठीक ଅଛି but he should know na he should know.
Yes, I should have. I ought to have.
Not you, the other Mr. Sarangi should have.
ठीक ଅଛି Sarangi ଯିଏ ବି ହଉ one or the other. ଆଉ ଦିନ ଆସୁ ତାହେଲେ Mr. Das ନାହିଁ ତ.
Sarangi is a great name. Anyway, great surname rather, not name. କାଲି କାଲି ଆସୁ ତାହେଲେ କାଲି ଆସୁ ଜାଣି ନାହାନ୍ତି କେମିତି
ନା ନା କାଲି କଥା କହୁନି ଆଉ ଦିନ ଆସୁ
ନେକ୍ସଟ ୱିକ୍ ସେଟା ବି ରଖିବା ନେକ୍ସଟ ୱିକ୍ ରଖିବା ସେଟା
ସେଇଟା ସାର୍ ଶାଶୁ ଫାଇଲ ମୋ ଶାଶୁ ଫାଇଲ କରିଛନ୍ତି ଏଇଟା ହଜବେଣ୍ଡ ଫାଇଲ କରିଛୁ ମୋ ଏଗେନ୍ଷ୍ଟ ହଜବେଣ୍ଡ ଭର୍ସେସ ୱାଇଫ so that's a connection actually nahi
very ठीक ଅଛି
these facts are different.
It's between Anugul and Rairangpur.
Between Anugul and Rairangpur and he was suggesting some middle place. Your lordship was also indicating, I don't know, but if at all your lordship feels that is to be transferred to a third place without recording a concession, Keonjhar will be the midpoint as far as these two ladies are
you must look at the ladies.
If these two ladies are concerned, if your lordship opines that, because lady is 51 years of age and she travels in the other case, she travels all over the state as a ମୋ ଓଡ଼ିଶାର ଅଛନ୍ତି ସେ ପ୍ରେଜେଣ୍ଟର ରାଇଟର and all that ମୁଁ ଗୋଟେ ସର୍ଟ ନୋଟ ଟେ ସାର୍ ବି କରିଦେଇଛି since judgment has not been delivered I'm filing it also.
No judgment in the other case it is ready but because of this case I thought Mr. Das will be aware since Mr. Das is not aware. You give him a copy and we will take it up this matter not the other matter.
No other matter ସାର୍ ଟିକେ ଦଉଛି କାରଣ ମୁଁ ସାର୍ କାଉଣ୍ଟର ଦେଇନଥିଲି
ଦିଅନ୍ତୁ ଯଦି ଦରକାର ପଡେ ମୁଁ to be mentioned ଆଣିବା ଆଉ କଣ sir we'll bring it on to be mentioned.
ସେଥିରେ ଦୁଇ ତିନିଟା paragraph only I have and there are other cases also filed at
file ରଖିବ ହେଲା So leave this matter next week. Mangalore, huh? On Tuesday, that is 17th. 17th.
Interim order was there.
Interim order to continue. Inform Mr. Das. Yes. 36. None appears.
Yeah.
Transfer from family court Puri to family court Khorda. Notice has-
You are appearing?
Yes, I am for the appeal.
Yes. What is your stand?
My lord, what happened in this case? I have filed a TRP CRL petition 50 by 2024. That is posted on the other day. What happened? She has filed a petition under 125 CRPC before the families of Khordha.
Families Khordha.
Yes.
Yes.
I have taken play that his wife and her family members has severely assaulted to me, and my hand is already handicapped. I have annexed that photocopy of that petition. That's why I'm not. I have filed the petition to transfer the case from Khordha to Puri.
Okay.
That case.
So let it come along with the other matter.
Yes.
Is this matter along with TRP?
TRP CRL.
TRP CRL number 50 of
2024.
2024 on সেটা কেবে করছি?
এটা বোধহয় tomorrow আছে বোধহয়। I have not.
সে দেখি যে কোন দিন করছি সে অনুসারে করে দেবো হ্যাঁ না? TRP CRL ডেট অফ পোস্টিং কো দেখি সে অনুসারে করব। Yes.
7.
Oh.
Transfer application at the behest of the wife lordship. The wife is filed in 125 proceeding before the learned court of
Anybody appearing for the opposite party? None appears for the opposite party. No, the learned counsel for the petitioner is present. None appears for the opposite party on repeated calls. On the previous occasion also there was no appearance. Hence the transfer application is taken up for hearing. कोई जगह कोई जगह?
Baleswar or Mayurbhanj ko 125
Allowed. Allowed.
Item 38.
May I please? Appearing through VSIM. This is a transfer application from Noyagarh to Barampur filed by the wife Millard. The opposite party has already entered appearance. Millard.
Who is appearing? Sulochana Patri. Yes. You are for the husband.
Millard, the husband has filed the divorce case that is at Noyagarh Millard. But the wife is staying in Barampur. He is a lady Millard and having no source of independent income Millard. It is difficult for her to travel 170 kilometers. And the husband is staying at New Delhi, Noida.
Your Lordship, the opposite party working as at Delhi, Your Lordship. The middle place is Bhubaneswar is suitable for transfer the family court Bhubaneswar, Your Lordship. That place is distance from the Barampur to.
Yes, what do you say? She is suggesting Bhubaneswar.
Barampur to Bhubaneswar is also.
Bhubaneswar is 85 kilometers, Barampur is 170 kilometers from Noyagarh, Your Lordship.
But anyway, Millard, the opposite party is staying at Noida, Millard. Anyway, he has to travel to Odisha on the date, Millard. And it would be much easier for him, Millard, rather than this lady, Millard. He is having no source of independent income, Millard. And it would be difficult.
He is working in Noida, no source of income.
No. The opposite party is working in Noida. Husband.
Acha.
But I am the wife.
So if we bring it to Bhubaneswar, what will be the problem? Noyagarh to Bhubaneswar? You wanted to come to Noyagarh instead of the case being at Barampur. If it is brought to Bhubaneswar, I think it will not cause inconvenience to any of the parties.
But for that, I have to take instruction. Lord. As per my instruction, Lord, he having no source of income.
All right. Learned counsel for the opposite party, in course of hearing, learned counsel for the opposite party suggests that the case can be transferred to Bhubaneswar instead of Noyagarh, as it would be convenient to both parties. Learned counsel for the petitioner wants to take instructions from his client. List this matter on
26 September.
26 September.
Item 39.
Interim order to
Interim order to continue.
Grateful.
Item number 39, please, my lords. Inadvertently, instead of filing requisites for speed post, my lord, we had filed for registered post, my lord. Your lordship may permit us, I'll file it today itself, my lords.
You have not filed the,
We have filed, but we had filed it for registered post instead of speed post.
all right, let it, the requisites file be accepted and notice be issued fixing a short returnable date.
Correct.
List this matter,
4th October.
24th October. Yes.
Interim
Interim order.
arrangement.
Continue.
Item for grateful mothers.
Item 40, same order. Same order. Same order, same order. ये previous से जा रहे same.
Item 41.
Interim.
Yes.
Interim.
Interim order will continue.
41, your lordship may kindly see the noting. It has been received with short signature.
We do not know whose signature is that.
Yes.
We'll have to take notice again.
Yes.
Issue fresh notice to the opposite party by speed post. Fixing a short returnable date. Requisites be filed within 3 working days. List this matter
4th October. Sir.
on 24th October. Interim order to continue.
Item 42.
Wife married, finally after notice has been issued, my noting is that AG has against sole opposite returned with short signature. Sorry. AG has against sole.
Notice on opposite party appears to have been served on his father as per the address statement given in the cause title. There is, however, no appearance. In order to grant one more opportunity to the opposite party to appear, list this matter on 24th October. Interim order to continue.
Item 43.
The notice was issued, my lord. From the noting, it appears that notice was sufficient.
Yes. From the postal tracking report, it is evident that notice on the opposite party has been served on 3/9/2024. There is, however, no appearance. In order to grant more opportunity to the opposite party to appear, let's this matter on 3rd October. If he doesn't appear, then
But interim order is there.
interim order to continue.
Time for the respondent number 2.
Appearing for the
Pursuant to your lordship.
video conference.
Pursuant to your lordship's order.
Yes.
Having the report as well as my bill expenditure bill.
সেটা দিয়ে খুলে দিতে হবে। Let them go through the report also.
But I cannot supply them copy.
No, I will write them. Without the knowledge, how can an order be passed? So what did you find?
Well, there is, your lordship may see that. I've given a detail. I've given all the photographs of the entire area, building statements recorded in local investigations from the neighbors, everything.
So we'll make copies of it and give it to both Mr. Sahu as well as Mr.
Saroj can collect on my behalf.
Yes, yes. खोल नहीं देखिए खोल फोटोग्राफ्स भी थे ना
The bill, expenditure bill.
সেটা শুনলি পরে
না না
এতে ব্যস্ত হচ্ছেন
কোর্ট মানে কোর্ট মাস্টার পচালে সেটা কোন মানে সেটা এক্সপেন্ডিচর সে পচালে
ମୁଁ ଭାବିଲି ବୋଧେ ଆପଣ କହୁଛନ୍ତି ସାଙ୍ଗେ ସାଙ୍ଗେ ଆପଣଙ୍କୁ କୋଉଠି କଣ କରିକି ଦେବାକୁ ପଡିବ ବୋଲି
କୋର୍ଟ ମାନେ କୋର୍ଟ ମାଷ୍ଟର ପଚାଲେ ତ ସେ ଦିଟା
ନାଇଁ ଦବା ସେଥିରେ ହେଳା ହବନି ଡୋଣ୍ଟ वरी
They had deposited on Thursday, but I went on Friday. I have not received that also.
Regarding money, there is no issue at all. You can pay it.
So Sri A.P. Bose was appointed as Advocate Commissioner by the court, has submitted his report along with several photographs. Let copies be made of the report along with the photographs and supplied to learned counsel for the appellant as well as the respondents.
R2. Respondent number 2.
Respondent number 2. Further, देखिए bill टा Sri Bose has also raised his bill of fees.
No, no, I've not raised fees. I've only given the expenditure amount. Fees your lordship will be.
Has given his bill of expenses. They have already paid 20,000,
Yes,
isn't it?
yes.
Let them pay further 30,000 to be shared by both.
Well, if that is paid in cash, it will be easy, if they can pay, if they can.
Yes, certainly. Why not?
Receipt.
But this will be over and above what they have already paid.
Correct.
It appears that it is seen that as per order passed by this court, both parties have deposited rupees 10,000 each. Some amount is available after expenditure. That amount, along with further 30,000 rupees, be paid to Sri AP Bose towards his fees, towards his professional fees. The amount of rupees 30,000 shall be divided equally between the appellant and the respondent number 2. Payment be made, shall we make it directly? Or we'll let it be paid through the court? It is always better to.
Yes, yes.
Yeah. The deposit be made before the court within 2 weeks. Is this matter?
Before the
2 weeks,
vacation,
we'll go through.
before the vacation, my lord.
Yes, sir.
It will be better if it is listed in the vacation, before the vacations. I'm very happy.
Vacation purvur karda, vacation purvur.
I'm coming to Cuttack because it is great festival of Cuttack. So I'm coming.
List this matter on 3rd October, Mr.
Yes,
Praturi, 3rd October.
Yes, at 2 p.m. my lord, yes, fixed time.
2 p.m. ko na 3rd October asu dekhe. 2 p.m. ko hoye bole.
I am there.
On such a deposit being made, the registry shall take prompt steps for release of the amount in favor of Sri Bose. Yes.
I say one.
Yes, please.
The earlier amount may be also released because that has not been released.
It is stated, it is submitted that the earlier amount deposited by the parties has not yet been released in favor of Sri Bose. Such being the case, the registry is directed to release the amount in favor of Sri Bose after following the usual formalities within a week from today.
Okay.
Yes.
I love that.
45.
May I please, my lord, I'm through virtual mode.
Yes.
Lordship, this is the first bail application of the petitioner, and the petitioner is in JC since 22nd August 2021. And in last more than 3 years, Lordship, the trial has not commenced yet. So, Lordship, I'm seeking a request to call the status report from the trial court.
All right. The court below is directed to submit a report as regards the status of trial. Is this matter? On 24th October.
Please,
This
madam.
order will be communicated to the court below forthwith. Yes.
Please, madam.
Case of 302, yesterday your lordship has released the other co-accused persons, and this petitioner were
Na kon? Na kon?
एମାନେ ଅଛନ୍ତି total
7 petitioners.
7 petitioner ଅଛନ୍ତି। ଏ ଯୋଉ 7 ଜଣ petitioner ଅଛନ୍ତି ତାଙ୍କ ଭିତରୁ petitioner number 1 ଆଉ petitioner number 5 ସେମାନେ similar footing ରେ ଆସୁନାହାନ୍ତି because assault is attributed to the petition number 1 and 5. So for the other petitioner concerns against them, no assault party is there.
No, my
But
lord. Petition number 1, 2, 3, 4, and 5 all are.
Did I see that statement?
Yes, madam.
My previous order.
Yes, ma'am.
The court has perused the statement of injured witnesses, namely Pratap Barik, Govinda Barik, and Manjulata Barik, available in the case. It's seen that the main allegation of assault on the deceased director is Dolia Deuri, not a petitioner.
No.
Kalia Deuri.
No.
Pintu Deuri is petitioner number 1. Yes. Bhisma Deuri, petitioner number 5.
My lord.
And Ananta Deuri.
Ananta Deuri is not petitioner.
So Pintu and Bhisma. Direct allegation against them.
No, that apart, the statement of Govinda Barik, my lord. Pratap Barik, my lord.
I've read Pratap Barik of I've referred to Pratap Barik of the last occasion.
Yes, referred, my lord. That thereafter they have also assaulted, my lord.
कौन लिखा है इस पर?
My lord, Amina Deuri, Abhi Deuri, Bhagina Deuri. That Bhagina Deuri is there, my lord. Bhagina. Subsequent is it Amina Deuri, Abhi Deuri, Bhagina Deuri, Dolia Deuri, Sonia Deuri. Sonia Deuri is there, my lord. Number 4. माने मो बड़ बापा कार्तिक बारिक सह मो बापा गणेश बारिक को धरी बाउंस ठेंगारे बाड़े रक्ताक्त करदेले सब्सिक्वेंट इंसिडेंट माला
This seems to be a little bit vague. गोटे बाउंस ठेंगारे 5 जण मरी किंतु बुझले. So I think the same order. 1 and 5 rejected habo.
1 and 5.
1 and 5 will be rejected. बाकी allowed habo. एई जो previous order का जो करा है देखो इथरे connected अछि सेम जिंस रहइबो ए देखो एम लिखंदो in such way the matter last सब लिख साला परे I am not inclined to allow the prayer for bail in respect of petitioner number 1 the नाटा लिखिबे and petitioner number 5 which is therefore rejected है ना.
Liberty be granted.
It shall be open to them to renew their prayer after examination of material witnesses during trial. As regards the other petitions, जहाँ लिखा है कर दो.
1 and 5
यही कर दो. Yes.
47. Make offense under 302 only, my lord.
Is that is available?
No, my lord.
This has come for the first time.
First time.
Earlier rejected. You are Ajit Kumar Sorangi.
201-376-2N.
Dead body of an unknown female was lying near a culvert with injury marks and causing complaints. This is the married the Mahdi. Get married on Basanta Patnaik.
Trial already started, my lord, but those witnesses are examined, not relevant, my lord. Those 2 daughters, my lord, let them be examined, my lord.
And 12 witness has been examined, not a single witness.
No, they are not relevant.
Yes. Heinous offense.
Yes, my lord.
My lord, the deposition made by all the 12 witnesses, not in a single witness given an.
What are the main witnesses?
My lord, those 2 daughters, my lord.
Yes. Have they been examined?
No, they are not been.
No. Then you renew a prayer after examination of those 2 daughters, or you seek withdrawal with liberty to renew a prayer after examination of those 2 daughters. No. How many? Serious charges, allegations are against you.
Suspicious only. No direct evidence is there.
Yeah, let us see. Sabutra direct evidence court as you. You had a illicit relationship with that lady. You had a telephonic conversation. You called her, took her on scooty. Thereafter, you strangulated her.
No, my lord, that is strangulated. But
disclosure statement is also there, and the 2 daughters who have spoken regarding
because
that.
he was.
No, this is not just a suspicion. This will be a circumstance. And there is a disclosure statement. That will be a strong circumstance.
Para 5, your lordship has indicated in the.
Yes, I have read it.
Yes.
So, it is open to you to seek withdrawal with liberty, or I will reject it. Permitted to withdraw with liberty to renew his prayer after examination of the 2 daughters of the deceased.
Item 48.
Present petitioner is my lord, is behind bar, my lord. Since 1 to 2022, my lord.
Ajit Malik.
Being charged under section 498A.
Reject.
306-34 IPC with an offense sanction 4 DP Act, my lord. They have
Second time reject. Second time with the interim bail. Third time.
4th round.
That IN number 1190.
4th round of कौन होगा Mr. Das?
Pardon?
4th round.
Delay trial round without interim bail file. Last witness informant has examined on 11/11/2022, man.
Yes.
But there is no substantial progress of trial, man. And
okay.
Cause of death is suicidal nature.
You are the husband?
Yes, husband.
Yeah, I have one.
Cause of death is suicidal nature, my
I have given you relief. 3
And-
months I have given you interim bail. How about it?
Not for regular bail, lordship has considered that interim application.
Your prayer is for interim bail
So we have
in this
filed
case.
that is 11/11/2024.
No, I had granted you interim bail.
Because in view of delay.
But here now you are claiming regular bail.
We have along with that regular bail, we have filed an application, interim application.
Can interim application to nahi? There is no IA. There is no IA. IA is
1190.
11? No, the IA is not there. Huh? List this matter tomorrow along with IA number
1190 of 2020.
1190 of 2024. Yes.
Serve a copy, let them serve.
And serve a copy in the State Council. Yes, serve it. You serve it first today. Yes, item 49. Okay, nice.
724. And who accused your lordship granted bail? Amjad Khan and Montu Pradhan. They are on the same footing.
Yes.
Yes, my lord, similar footing. He has supplied the injured statement, similar footing.
Same footing.
Omnibus allegation
All
against all, my lord.
Same order, huh?
उक्त 4 जन मिसी
May be grievous will you लिखा इतला.
yes.
Item 15. None appears 1 week after.
51.
ST Act involved. Similar co-accused annexed to.
Is there a 307 matter?
307, 395 is there.
307 is your order. So that order will be there regarding that injury.
Similar co-accused annexed to.
All at all. Same.
Item 52.
May I please your lordship? Lordship, in this case, already 7 co-accused persons are released on bail, lordship. The offences of this case, lordship, 307, 302, 326, 120B of and 34 of IPC, read with section 25 IA and 27 of Arms Act, lordship. Lordship, present petition wasn't present at the place of occurrence, lordship, and nothing was seized from.
Bring the case diary. Bring the case diary.
As I remember, my lord, that one.
That auto rickshaw murder case. The driver of that auto rickshaw murder.
देखिले चिन्ही परिवी later on TA parade has been conducted and specifically he has named 3 persons.
Yes, lordship, he was not identified in TFR.
Let us see. Let us see. Let us see.
Yes.
Approved. The case diary be obtained for perusal of the court. List this matter on 26 September. No course of action shall be taken against the prisoner till then. Sarla. Yes, Mr. Balkrishna.
37, there is a noting that consolidated cost declares not filed, I have already filed. And there is a confirming judgment of Sonpur. The client is coming on Saturday, the material instruction. On Tuesday, let it be on Tuesday.
Item 37.
37.
Amar कौन जाए जाइए?
46.
46 जाए जाइए.
37 was passed over.
37 was passed over. We'll take it up next week. कि तपर week रे huh? 2003 matter, Mr. Balkrishna.
No, that's why I'm saying on Tuesday.
ये Tuesday तरह week रे ऐसे पूरा entire week रे entire week का weekly list ऐसे हो. List this matter in the week commencing 23rd September. Yes.
Item number 46.
I may pardon. Item 8 weekly list. But that date the council appearing with the respondent as president intimated he said that brief has transferred. He has also mentioned yesterday that notice we go on substitution and limitation. I filed a substitution petition limitation along with setting aside appointment. The notice may go. Let
us pass that order tomorrow. Please remind me so that I'll pass that order because tomorrow is the last day of the weekly. So weekly list will be exhausted by publication. Yes.
Yesterday's first matter item 26 that your lordship called for the substitution application and amendment.
All right. There's only notices to go.
Notice is only proper the others.
What item?
Item 26.
Item 26 नहीं ऐसी ही चीज petition order हाँ petition order नथिला order टा केमती था आइए कितने তিনটা আইয়ে রে issue notice to the proposed LRs by registered post, returnable within 4 weeks. Requisites be filed within 3 working days. Let this matter in November will take it up. যদি 2003 ম্যাটার বাট তা পূର୍ବରୁ ଆଉ adjust କରିବୁ মাসে ତ ନିଶ୍ଚୟ ହେଇଯାଉଛି କେବେ କହିଲେ in the week commencing 18th November.
Item number 46.
For the respondents.
46. Oh, that Mr. Hota was here just now.
Some of the respondents.
No, Mr. Hota was just now present. আচ্ছা ও ঠিক আছে অন্য কোন পাশে ওর আছে ছোটটা মাটি সি সারি না সি ଆଉ ଟିକେ ଅଛି ତାଙ୍କ ସରି ଯାଉ ତାପରେ ଆପଣ ରିପ୍ଲାଏ ଦେବେ କାଲି ଦେବେ କାଲି ବି ସରିବନି ନେକ୍ସଟ ୱିକ୍ କୁ ଯିବ
Passover item 43 and 44.
Yes.
Matter be taken up after vacation, my lord.
2015 matter?
Because, my lord, in item 43, IA is one IA for additional evidence. IA 1006, that has not come on record. 44 also.
43 and 44 as requested, let's this matter. Correct.
So the week commencing 11th November.
In the week commencing 11th November, yes. Any other small matter? Yes, Mr. Ponda? 49 day? No, 46 টা সরি যাও ছোট ম্যাটার কেউ 46 টা
না
43.
Sorry, sir. 43 টা 49 will go.
Daily through copy.
ନା ମୁଁ ସାର୍ କପିରେ ସେ 43 ମୁଁ କହିଛି ସେଟା ଅର୍ଡର 49 ସେ ଦେଇଛନ୍ତି ଆଡିସନାଲ ଏଭିଡେନ୍ସ ସେ ତ ଇଏ ହବ ସେ ଅପିଲଟାକୁ 2 ମାସ ହେଲେ କରୁଛି
ସେ ଆଉ ଟିକେ ସର୍ଟ ଡେଟ୍ କରିଦେ
43 ରେ କାହିଁକି ନା ସେଥିରେ ସାର୍ ଯୋଉ ଦେଇଛନ୍ତି ଆଡିସନାଲ ଏଭିଡେନ୍ସ ଅପିଲ ଶୁଣା ହେଲା ବେଳେ ଶୁଣା ହବ
28th August October sir.
ଆଜ୍ଞା
item 43 week commencing 28th October. ତା ପୂର୍ବରୁ ହେଇପାରିବନି ଆଡଜଷ୍ଟ କରିହବନି
ନାଇଁ ସାର୍ ମୋର ସେଇଟା କହିବା କଥା ଇନ୍ ଦ ମିନ୍ ଟାଇମ୍ ମୋ ଲୋକ ଯିଏ ସେ ମରିଗଲେଣି ଜମି ମାଲିକ ଘର ମାଲିକ ହେଇକି ସେ ମରିଗଲେଣି ପିଲା ଛୁଆ ପକ୍ଷଭୁକ୍ତ ହେଲେଣି
2015 କେସ୍ କଣ ବ୍ୟସ୍ତ ହଉଛ
ନା ସେଇଟା
15 ପେଣ୍ଡିଂ ରହିଛି ଆଜି ଯାଏ 9 ବର୍ଷ ହେଇଗଲାଣି
ନାଇଁ ସାର୍
at least this will be heard and disposed of.
ଆଜ୍ଞା ସେ ତାଙ୍କରି ଇଏରେ ଆଜ୍ଞା ଏଥର ଗଡ଼ିକି ଯାଉଛି ମୋର ସେଇଟା ହଜୁର ପାଖରେ କହିବା କଥା ଆଉ କିଛି ନାହିଁ
ତାହେଲେ ଆଉ ଟିକେ ସର୍ଟ ଡେଟ୍ କର ଦେଖ
ପଇସାରେ ଆର
ଆଉ ତା ପୂର୍ବରୁ ହେଇପାରିବନି
7th October 3 ଦିନ ମାତ୍ର
ଆଚ୍ଛା 21st October ତା ପୂର୍ବରୁ ନାହିଁ ପାରେ ସେ ଆଡଜଷ୍ଟ କରିପାର
ନାଇଁ ସାର୍ ମୁଁ ସେଇଟା କଣ ଯୋଉଟା ହଜୁରଙ୍କ ଡାଇରୀ ଅନୁସାରେ କିନ୍ତୁ
item 43 21st October ମାନେ week commencing item 44 ଯାହା ହେଇଛି ଆଉ yes
ସେ ଯେଥର ଯୋଉ ଦିନ ପଡୁଛି ସେଇ ହିସାବରେ ଟାଇମ୍
ହେଲା କଣ କରିବା once it becomes part and it will be disposed of that you know
ଆଜ୍ଞା ମୁଁ ସେଇଟା
ହବ କଣ କରିବା yes
item number 46
how much time will you take ତଥାପି
45 minutes ତ ଭାବୁଛି ହେଇବ
half an hour
ଆଜ୍ଞା
30 minutes 30 minutes
ତ ଭିତରେ ସରିବନି କେତେ ପାଠ ରହିବ
ଏ ପାଠରେ ତ ରହିବ ଏମିତିରେ ରହିବ
ଡେରି ହେଲା
ଦେଖନ୍ତୁ ଆପଣ try to please conclude this is a second appeal after all we cannot go into all those facts
no unless the facts come in the picture my lord may not understand the judgment itself what has been referred.
No, that is all right. Yesterday you have referred to many facts which I have also taken note of. Yes, begin.
My lord. Shall I refresh or?
No, not necessary. Not necessary. You start from where you left off yesterday.
Maybe let us go to the judgments. Judgments were. Judgments, my lord, 3 to 4 paras only.
Yes.
In this trial court and also in the appellate court, I have
So
Yes.
submit. But before that, my lord may kindly consider that prior to 1945, Jaydev died. Jaydev Ganeshwar's father. During that time, all partition no. Partition not by meets and bounds, but by way of positions, separate positions. Now, 1950, the dam project acquisition was done. 52, the OEA came. He was the Kharpusdar. The Ganeshwar was the Kharpusdar. After the death of this Jaydev. So, there is no Kharpusdar. It is all abolished by from 9 to 52 under the OEA. Now, 1955, the dam where all the dams, the lands acquired were not utilized for the dam. Remained as that. They wanted to settle it, resettle, and a rehabilitation process started. 1956, as per the application, so we get the applications. Now, here we may consider one thing, my lord. The Ganeshwar, after death of Jaydev, inherited 103 acres of land. His land, it is exclusive for the Ganeshwar mill. 70 acres around have been acquired. 70 acres. That Exhibit 1 will show. The Kunti number 2, some lands were acquired. Kunti number 2, Ganeshwar and others. Kunti 1 is Ganeshwar alone. So, because of that, my lord, on application, now in the Additional Commissioner HLO, in Revenue Case number 176 of 1956-57, which is the order and Exhibit 2 yesterday shown, 8 acres of land was allotted for reclamation. The action was given under Annex 3, Exhibit 3, saying that you reclaim it within 2 years. Subsequently to this, my lord, in 1959, another notification came that the period was extended, the reclamation period, not 2 years, but 3 years. So, in this way, some so far my knowledge is there, 19 Exhibit 2 and 28 in that annex. That notification I have not given because it was not relevant for me. So these benefits have to be resettled. The government, the HLO, Additional Commission decided that I will be given 8 acres. By the time Kharpusdar is not there, it is in my individual capacity I applied and I got the individual name itself. My lord. So, my lord may, after going such things, my lord may look at the finding under issue number 4 and 5, which the trial court was. That was, my lord, there were 9 issues. One is maintainability, another is cause of action, another is judicial. The usual, my lord, 4, 5 were taken up together because right title interest is to be decided, and possession in 6, possession to be confirmed, and 7, 8, 9, that is usual. My lord, here, my lord, yesterday I could not name the PW1 I was telling. My lord, may kindly see para 5, same page, issue after below issues, my lord. In support of the plaintiff, 4 witnesses examined SM Patnaik. This is PW1 who exhibited Exhibit 1. This is the government document. Even Exhibit 2 was also government document.
Yes.
It is told, my lord. It is mentioned here. The register 1, my lord, made 2-3 lines after, my lord.
Yes.
Register number 1, land scheduled register of property villages marked at Exhibit 1 and serial number 1 to 29 on Exhibit 1 as matter of Exhibit 1 by A. Copy of order passed by Additional Commissioners Hirakud Dam Organization Sambalpur in Revenue Case number 176 of 1956-57 marked as Exhibit 2. My lord, both the documents we have seen, that is the official documents given by the SM Patnaik. And notice of additional commissioner to the Ganeshwar, my lord, that was annexed exhibit 3. And letter of Tahsildar, copy of letter dated 22/5/1990, the scheme, the decision of the government from it is exhibit 4. It is written from Tahsildar because it is received from Tahsildar, that's why it is written. But it is the scheme of the government. My lord, shall we go to the judgment part or the exhibit first?
Judgment को लेवल बेटा judgment तो decide ही थी ना अब तेरे exhibit को
exhibit ना exhibit टा है जी exhibit 3 देखी देले my lord
ये exhibit टा बाहर करो
exhibit टा खाली देखी देले कौन होगा my lord will be more clear because the entire case stands on exhibits.
Okay.
Exhibit 1 to my lord already seen, so not necessary we are going to. But one thing may kindly see. Yesterday I was telling that Kunti 1 was for seed property and Kunti 2 was full caste property. Here, my lord may see exhibit 1 first page itself. My lord might have seen Ganeshwar Singh, Pita Joydev Singh, Kharposdar, seed, bracketed seed property. This is only meant for Kharposdar's exclusive family matter.
Yes.
And the other was khud caste. During the Kharposdari, it was acquired, but this was abolished in 1952. Afterwards, he became individual possessor. Now, kindly look at Annex 4, Exhibit 4. Exhibit 22 May 1990. Government document. It is issued by Government of Orissa Revenue and Excise Department. Well, see, sorry, other settle colony, there was agitation, etc. That some Panda from Lakhanpur Tahsil something, they agitated. Thereafter, it was decided. Readable or not?
Yes.
Readable, not readable.
So the proceedings of the meeting head on.
No, that is different. Exhibit 4 hala, the Government of Orissa Revenue Excise Department dated notification number 23861.
Yes, I got it.
Oblique R, dated 22 May 1990.
Yes.
This one. Madam, let me submit, madam. The para 2 itself.
Yes.
The procedure to be adopted outside area allotted to the Orissa Power Generation Corporation in the matter of grant of tenancy rights to the displaced persons of Hirakud Dam project would be as follows. Madam, the Tahsildar will conduct an inquiry on the spot about the actual possession of the persons concerned. During the inquiry, he should ascertain whether persons in actual possession is genuine housey or not. Madam, genuineness to be first. The occupation of the legal heir. Madam, if the holder of the DC pata holder is not there, then only successors. Legal heir or successor of the housey will be accepted. During this inquiry, list of housey, that's also matter. So only legal heir and successor. Well, next ballot, B, next page. B, the subcontractor will verify the report of the Tahsildar, actual occupation, so and so, that is the supervisory workman. Final list of oustees, number C. Final list of oustees or the successors be acted upon since there are in actual occupation of the strength of Bandi Patas. Bandi Patas means the annexed to allotment, exhibit to allotment is itself thereafter after reclamation they accepted, they filled in the sector. So that is the Bandi Pata. The Bandi Patas in where the Bandi Patas are not produced on the basis of their status, they are genuine oustees established during inquiry. Even if it is not available, then also it will be decided in that. Now the D, the oustees whose status as oustee is not re-established during inquiry will be treated as final and allow alertees and land in their favor, allow the alertees and land in their favor should be allowed to the extent of allotment of DC quota, and what the DC quota is not produced to the extent of 1 standard acre subject to actual occupation. Now the E, my lord. Since the deputy commissioner has allocated, my lord, this is important. Since the deputy commissioner has allotted the land and the status is finally re-established during inquiry, my lord, during that inquiry, 1957-58, my lord, inquiry, they should be treated as a genuine alertees and mutation proceeding initiated for recording their names in the record of rights. So this was the directions. I have filed 2 other documents along with the plaint, my lord. It is not exhibited, but in the plaint it is there. That is regarding the, after this order, the Chamber of Minister Revenue, there was a meeting, proceedings of the meeting dated 17/12/1996, which is reflected in the judgment of the trial court. There, my lord, they have discussed a lot regarding, it is coming under Lakhanpur Tahsil. So they decided, said that during the, I'm just submitting few lines from that, my lord, proceeding. He further held that the DC quota holders have transported the joint as also suggested that by step-by problem of settlement of land in favor of the DC quota holders and their legal heirs, either found in possession after inquiry. Only legal heirs, my lord. First of all, the mutation favor of DC quota holders or the legal heirs should be allowed through special right, which is the line already decided, quoted by the trial court judgment. Now, on the basis of this is a special right, this was relied on in the judgment matter. Another factor, another meeting, minutes of the meeting problems of Austis. It is in the next 1997 meeting, my lord. 15/1/1998 by the RDC, that is review meeting. There they said, after these 2 documents, they said regarding Lakhanpur Tahsil. In Lakhanpur Tahsil, this is in page 3. In Lakhanpur Tahsil, where the maximum area has been allowed by the DC potash to the extent of 3,184 acres to 1731 beneficiaries. The extent of land recorded in the royalty status during settlement of person has not yet been worked out. However, the Tahsildar has initiated 50 mutation cases involving 200.68. Mutations have been allowed in cases of 82 beneficiaries. The review meeting, they said. Now, even the Tahsildar stated the name of the disciple are not residing in the village. The commission instructed the present address of the may be ascertained and the disciples concerned persons be sent to Tahsil and disciples alertees residing in the same extent of land under the position of the alertees. Next, para 6. The Tahsildar wanted to know about the disciples recorded in the Gochar, Gramya Jungle, Sarva Sadharan Khata because it is in government khata. After acquisition, it all went to the government department and remainder it is for the resettlement purpose. So they said the Gochar, Gramya Jungle, Sarva Sadharan Khata as per the current ROR. This point had been discussed in the earlier meetings and instructions were issued to the proceedings of the meeting to allow mutation in favor of the disciplity as per their possession, since land was allotted along with right title as back as 1959-60. No de-reservation proceeding is required. That means they said that Forest Act came later. So all these things did not be de-reserved. So not to delay the matter. So to say, not to delay the matter. Now kindly look at Annex 5, my lord. Exhibit 5. Exhibit 5, my lord. This is the proceeding on the basis of annex of this exhibit 4 and these two proceedings, decisions, my lord. Now, the Tahsildar Lakhanpur started the case, my lord. Initiated the case. I got it, my lord. There I want to show one thing. There are many pages, but unnumbered. This is regarding second case, 485 in 1966. Hirarama.
Yes.
My lord, that I want to show something, my lord. They in the order sheet, I have read that it is to be the Tahsildar decides orders that it will be decided in favor of the legal heirs. Now, what happened while the inquiry has been done in the same, my lord, may kindly see in the document. Yes, here, my lord. It is, my lord, may get it or not, I cannot say. Page 10, internal, the official page number 10. Page number 10. Where the 29/8/2000 order has been passed of the Tahsildar. Got it, man?
Order dated?
29/8/2000. It was the relevant date for the suit.
Yes, 29/8.
Got it, man?
Yes.
My lord, the order which passed received the field verification report of Amin S. Bagh. My lord, yesterday, while doing two names were come up, my lord, in the plaint itself, S. Bagh and A something. So this S. Bagh. It reveals further, it reveals
there is now a proof.
There is none in possession of the DC permission holder and may be allotted to so and so.
No, DC permission holder may be allotted land in the
may be substituted by legal heirs. This is important, my lord. What I was intending to just show before my lords.
So since landholder is dead, he may be substituted by legal heirs. Yes.
They are saying that it is contrary to the earlier, my lord, the earlier showed, my lord, the four sides of the suit line. Estate is showed.
Yes, yes.
Foregoing this, ignoring that, they have done this. They have not visited to the spot. It is all done behind the back. Now, thereafter, my lord, the next page. Next page, thereafter, my lord, page 20, internal page 20, 21. This is relevant. Hello, what it meant?
Date question.
Yes, ma'am. This is occupational land, the application form. There is a format is there.
Yes.
Officer conducting inquiry, escape Patna, additional Tahsildar.
Yes.
Got it, ma'am. Thereafter, my lord, may
after the order sheet. So after the order sheet.
That is, my lord. This is not order sheet. Memorandum of inquiry.
I'm saying after the order sheet.
After the order sheet.
There's an order. There is also an order.
This is not an order. This is
no. There is also an order. 27/5/2005.
Oh, there is. I have forgotten that. I am going to 1/11/2000. The order is there.
Yes.
Now I am going to the inquiry, which my lord was. I was just submitting that there is no full inquiry. That is what I'm telling.
Yes.
Additional Tahsildar, escape Patna, additional Tahsildar. Now, details of inquiry of this serial 5.
Yes.
Got it, my lord?
Yes.
Name of the village, so and so. Name of the address of DC Pata Aloti. my lord Ganeshwar Singh, son of Jayadav. My lord, got it, my lord?
Yes.
Now, whether Disipota is alive or dead, dead. Now, I will come to genealogy letter. I just next page, my lord. Next page. Area was mentioned of the top, my lord, 8 acres. Now, HLO revenue cases given, my lord, which was already referred. Exhibit 1, Exhibit 2, and later these were corrected. The lines were correct. Lines were cut, my lord. As per genealogy, they said. And my lord, left side, who has signed, my lord? My lord, got it?
Yes.
Who has signed, my lord? Who has signed, my lord? Let's see.
Yes, Tanaka.
6, column 6, man.
Yes.
Gajraj Singh. Got it? Response number 1. So, we are not present there. Now, genealogy was relied upon. Not on previous page, my lord. What they did, my lord, successor of Ganeshwar Singh to be added as in the mutation, my lord. But what did they? They went back to Jayadav, saying that it is Jayadav's property. So we are equally, we have got equal right. That's why they say they joined. And they took the plea that I am the Kharposdar son, Karta of the family. So I am looking after everything. This is Jayadav is to be accepted as the not the Ganesh. So they decided everything. Now they even ignored the appellant filed one petition, my lord, in 1998. 13/8/1990. My lord, may kindly internal page 56, something like that.
Of this exit 5, my lord. Not getting there. I'll show my lord.
এটা ঠিক করে রাখনা তো এই দেখি খালি দেখি
Due respect to our children, I requested that we have been allotted 8 acres of land in village Kirarama out of lot number 67/9 by the additional deputy commissioner HLO Sambalpur by the order dated 7/7 or the copy of this order is regularize this matter on behalf of Deepak Kumar Singh.
My lord, apparent, another apparent. But there the one line needs to be added, my lord, on behalf of G. Singh. My lord, just
on behalf of G. Singh.
That was not there.
Yeah.
That was not there earlier. So it is in 1998, my lord.
Yeah.
That is in 1998.
Yes.
But when we got the certified copy, we came to know this. We got the certified copy in 2003 after the knowledge only. So this is the way Tahsildar decided in their favor, saying that Jayadav, original landlord, Jayadav is the legal, one of the legal of the Ganeshwar Singh. So my lord, may kindly see. Now we'll go to the judgments. After going through this, my lord, judgment, my lord, issues number 4 and 5. These issues are taken up together for convenience as they are most vital issues being linked each other, linked to each other for proper adjudication of this case. Plaintiff has claimed C and proforma defendant number 7 to 10 are exclusive owners of the land, having absolute right, title, interest, possession as successors of Ganeshwar Singh, in whose name Disipota Exhibit 2 was granted as land house to Hirakutan project. It is further contended by the plaintiff that the issuance of Disipota Patta by the Deputy Commissioner Hirakut Land Organization in respect of the suit land, Ganeshwar Singh reclaimed it as per the guidelines and the instructions contained in order passed by the Additional Deputy Commissioner Hirakut Land Organization Sambalpur, 17, 18, 1957. This is the date, my lord, might have seen Exhibit 2 in revenue case number 176 of 1956-57 and remained in possession. My lord, thereafter, they decided the. Let us go to my lord. My lord, go to the name of Ganesh Singh alone is to be looked into. Column 18 of DC Patta, by Exhibit 2, my lord, yesterday my lord have seen. Exhibit 2 per se reveals that same was issued in the name of Ganesh Singh alone. In respect of the suit land as land authority of Hirakud Dam project, whereas column number 1 of it reveals that the DC Patta has been issued in the name of Dino Krishna Rai and others. Similarly, column number 14, 15, 16, my lord, yesterday I showed, my lord, Kokia. 14, 15, 16 reveals that DC Patta has been issued in the name of 3 sons of Kokia. Yesterday I said, my lord, 2 acres each. But they only 6 acres, 6, only 8.8 has been acquired under Exhibit 1. But the learned advocate appeal for the defendants, number 1 to 6 tenuously submits that the DC Patta itself reveals that same has been issued in respect of 1 or 2 acres. My lord, it's very important. 1 or 2 acres in favor of different persons. But in column number 18 of it reveals the DC Patta has been granted in favor of Ganesh Singh in respect of 8 acres of land. Such a major portion of land in respect of which DC Patta has been granted in favor of Ganesh Singh goes to show that the same has been granted in favor of Ganesh Singh and his brothers. Because it is 8 acres. So it has granted for others. This submission of the learned advocate appearing for the defendant number 1 to 6 cannot be accepted. In as much as it appears from column number 14, 15, 16 that DC Patta has been issued in the name of 3 sons of Kokia in respect of 6 acres of land. So, if the same has been granted in favor of Ganesh Singh and his brothers, the names of brothers of Ganesh Singh would have been mentioned in the other column there. He denied it. Because one family, 3 brothers, 2 each. I got only 8. They wanted that it is for all purpose only done. So, this was denied. Now 10. From Exhibit 1, the certified copy of notification 130, Hirakud Dam project 3955, my lord, the Exhibit 1 yesterday seen. It appears that Ganesh Singh was the Roy in respect of HS Kunti number 1, and Ganesh Singh and his brothers were Roy in respect of HS Kunti number 2. So a question arises as to why the names of brothers are admittedly stepbrothers of Ganeshwar have not been mentioned in HS Kunti number 1 when their names have been mentioned in respect of HS Kunti number 2. Admittedly, land from HS Kunti number 1 and 2 have been acquired for the Hirakud Dam project, but DC has been granted only in the name of Ganesh Singh. The brothers of Ganeshwar or his successor have not challenged the grant of DC in the name of Ganesh Singh alone before any competent authority. They have not also filed suit challenging the grant of DC by Exhibit 2. DC by Exhibit 2 could have been granted in favor of the brothers of Ganesh Singh in respect to land acquired from HS Kunti number 2, as the names have been mentioned in the notification number 180 of Hirakud Dam project dated 3/9/55 in respect of HS Kunti number 2. There is also no pleading up in the WS filed on behalf of the defendants number 1 to 6 that the grant of DC in favor of Ganesh Singh is illegal and also not in accordance with the available documents relating to the ownership of HS Kunti number 2, in respect of which notification mentioning the name of Ganesh Singh and his brothers as tenants. The learned advocate for the defendant number 1 to 6 submits that the DC Exhibit 2 was not challenged on the assumption that it would inure to the benefit of all brothers of Ganesh Singh. How? Manipulation, my lord. This submission of the learned advocate different number 1 to 6 cannot be accepted, as nothing has been mentioned in the DC Patta Bhait Exhibit 2 that the same would inure to the benefit of the brothers of the Ganeshwar Singh. No evidence, oral or documentary, has been adduced on behalf of the defendants 1 to 6 that the benefit has been given to all the brothers of the family through DC Patta had been granted in the name of one brother of that family. Apart from that, land acquired from HS Kunti number 1, some land has definitely been acquired from HS Kunti number 2 in respect of notification bearing number so and so Exhibit 1, mentioning the names of Ganeshwar Singh and his brothers have been issued. Further, Exhibit 1 reveals the names of other tenants in respect of some plots of HS Kunti number 1 has been mentioned. Similarly, the names of other tenants have been mentioned in respect of HS Kunti number 2. But the Exhibit 2, the DC Patta has been granted in favor of Ganeshwar Singh. My lord, next para, 11. Dispute, my lord, it will complete, my lord. 12 is the last. So the dispute, that is, the right title interest of the parties of the suit land, the case land, is to be adjudicated based on the DC Patta Bhait Exhibit 2. Further, the learned advocate or the plaintiff also submits that Exhibit 2 is apparently clear from DC Patta issued in favor of the land house to provisional for the purpose of reclamation only, and the process of reclamation is required to be completed within 2 years from the date of issuance of it. Failing with the oustee would lose their right and lands might be given away to other persons. That is written in the Exhibit 3, my lord. Further, the advocate for the plaintiff has from the column E of the letter bearing number so and so, that is Exhibit 4, my lord. Our Government of Orissa Revenue Excise Department prescribed that since the Deputy Commissioner has allotted the land, the status re-established during inquiry, they should be treated as genuine allottees, and mutation proceeding initiated for recording their names in the rights in the record of rights accordingly, and in the proceeding of the meeting held on 17/12/96 in the Chamber of Minister of Revenue in the Secretariat to discuss the problems of the displaced persons of Hirakud Dam project. It has been specifically observed that all mutations in favor of DC Patta holder or their legal heirs should be allowed through special drive, which my lord, from that, it was one of the conditions of the DC Patta that allottee should remain land within 3 years.
Reclaim the land. Reclaim the land.
Reclaim, that is separate. Here it is written for the second notice.
No, reclaim. What are reclaim?
Yeah, my lord. Should reclaim the land within 3 years. But in our case, it is 2 years. My lord, next, my lord. Can be next page. So he submits that when the successor and 4 brothers of Ganeshwar and were not legal heirs of DC Patta holder, 4 brothers of Ganeshwar Singh were not the legal heirs of DC Patta holder, the mutation of suit land in their favor by Tahsildar Lakhanpur is illegal. On careful perusal of the minutes of the proceeding and the above letter of Government of Orissa Revenue Excise Department Exhibit 4, it is quite clear that only the legal heirs of DC Patta holder are entitled to the land allotted in favor of their predecessors as land house. But here in the case at hand, DC Patta mutation case number 7/98, Exhibit 5, has been mutated in favor of all the successors of Joydev Singh, taking into account the status of the present parties as the successor of Joydev Singh, in whose name SS Kunti number 1 and 2 explicitly recorded. The Tahsildar has not taken into account the fact that DC Patta in respect of suit land was issued only in favor of Ganeshwar Singh, who is the predecessor of the plaintiff and defendants number 7 to 10. So the Tahsildar cannot go behind the DC Patta as per the instruction of the government contained in the above letter and minutes of the proceeding. Now, next para. Defendant number 1 to 6 in the WS have claimed that suit land was reclaimed by all the brothers of Ganeshwar Singh after its allotment, for which the successors are entitled to get share of it. This is the first thing they are pleaded. It is seemingly clear from the proceeding of the meeting dated 17/12/1996 that land should be mutated in favor of DC Patta holder or their legal heirs who had reclaimed the land allotted to them as per the condition of DC Patta. The DC Patta Exhibit 2 per se reveals that the disputa holder would comply the process of reclamation within 2 years, or else they would lose their right to be recognized status as rights. Nowhere it has been mentioned that the family members of disputa holder who would reclaim the land, their names should be mitigated. This is a false plea that is also denied. So this submission of the London advocate for the defendant 126 is not acceptable. Grant of disputa in respect of government land in favor of the land ousting of Hirakud Dam project and its subsequent reclamation within the stipulated time, within 2 years within 2 years of grant, is a decision of the state government. Similarly, to mutate the allotted land in favor of the disputa holder or their legal heirs is a special right, also is a decision of the government. The government has not instructed the concerned tahsildars to mutate allotted lands in favor of the successors of originally recorded tenants of HS Kuntin, from which the land was acquired from Hirakud Dam project. So the mutation of the suit land in the names of the successors of Jaidev Singh, original recorded tenant HS Kuntin number 1 and 2 in disputa, mutation number 7/98 by the Tahsildar Lakhanpur, and the order of the sub-collector Jharsuguda upholding and confirming the order of Tahsildar in mutation appeal number 12 of 2003 are not within purview and ambit of instruction of the government, and are also not in conformity with the decision of the government as per the letters discussed earlier. Further, one aspect is to be looked into as contended. Our one of the plea was, let us say for the sake of argument, not conceding, that is a joint family property. In case, it's not a fact. Then also Hindu Mullah law, Mullah's Hindu law, Article 233, that is discussed. But we have taken a plea that whenever a grant is given to the joint family, Karta, it will be in favor of Karta alone, unless it is decided that it is mentioned that it is for the family. Here, further, one aspect is to be looked into as contended by the learned advocate appearing for the plaintiff, that when the government grant when the grant has been even to a member of joint family, even to a member of the joint family, the same is to be treated as the separate and self-acquired property unless it appears from the grant that it is intended for the benefit of the family. As per the provision of 233 Hindu Mullah law, Hindu law Mullah bracketed 233 bracketed 3 of the Mullah Hindu law 16th edition prescribes that the government grant in favor of a member of a joint family property is his separate property unless it appears from the grant that it was intended for the benefit of the family, and the said grant is subject to condition mentioned in section 222 of the section of the Mullah Hindu law. My lord, the next from disputa exhibit 2, it does not appear that it was intended for the benefit of the family. So the Tahsildar Lakhanpur has acted beyond his jurisdiction by ignoring of disputa granted in respect of the suit land in favor of the Ganeshwar Singh and above position of law, where disposing of the disputa mutation case of 7/98. Similarly, the sub-collectors should have also ignored the above fact and submission of law and instruction of government while disposing of the mutation appeal number 12 of 2003, for which the both order passed by the Tahsildar Lakhanpur in the above mutation case and appeal, it will not confer any right title interest in favor of defendant number 1 to 6 in respect of the suit land, and it will not also strip the exclusive right title interest of the plaintiff, pro forma defendant 7 to 10, which they have acquired alone over the suit land by way of succession and inheritance as successor of Ganeshwar Singh, in whose favor disputa exhibit 2 has been granted, and in this respective suit land according to the issues are answered. So it is exclusive property, it was decided. Now issue number 7 regarding the issue number 6 and 7 regarding possession, etc. They said the last paragraph, who are the last 2 lines, who are the exclusive owners of the suit land have a absolute right title interest thereon on the basis of the disputa, which have been dispossessed.
Basing on the findings on the previous two issues, no?
Previous to the next para 12 manner. Now this is regarding jurisdiction, maintainability, and limitation.
In favor.
Because that was, my lord, 2000 behind the back it is done. 2003 we go, no, we knew this thing. Thereafter we went in appeal. Appeal also disposed of one. The partition was decided in our favor. They were set aside the Tahsildar's order. Now the right title interest issue was raised because it is dismissed in favor of the respondents. So accordingly, it is not barred by limitation. Now,
what happened in the appellate court?
My lord, this is very interesting. He has acted as agent of respondent number 1. My lord, may kindly see. My findings, page 6.
Yes.
My lord, he framed another issue for himself. In view of the pleadings and the parties of the submission made, this court has to determine whether the suit in the present form is maintainable, whether the respondents have got exclusive right, title, and interest over this shared property, and their possession over the same is required to be confirmed, and suit property is the joint family joint property of both parties. Findings. I have, my lord, I have carefully gone through the entire evidence. Let us go to, my lord, mid, my lord, in page 7, mid.
Yes.
Just 5 to 10 lines on the sole dispute. It appears from the pleadings that the sole dispute between the parties is with the allotment of property by Exhibit 2. While the respondents have claimed that whenever exclusive property of Ganesh Singh was acquired by the project by Exhibit 1, he is the exclusive owner of the suit property allotted by Exhibit 2. This is not a, but just, it is not a case. What is stated is not correct. Now, on the other hand, the appellants have stated that actually the properties of Joydev Singh have acquired. For the project, legal heirs, that is, both parties are entitled to suit property. It is also submitted the contents of Exhibit 2 are cannot be considered confirming exclusive title of the property in favor of the Ganesh Singh. Now they developed a new plea, my lord, here, saying that, my lord, they took the decision of good works. My lord, it is submitted. My lord, I'm reading out the opinion of the appellate court, my lord. It is submitted by
page,
same page. Yes. Same page. 2-3 lines.
Yes.
It is submitted by the learned advocate on behalf of the appellants that the learned trial court has erred in by putting the entire burden of proof on the respondent. What is to be proved? Entire burden of proof, the court shifted to respondents. What is the question? We are submitting by our exhibits. Everything on documents. Everything on documents. But they took the plea like this, madam. And that was accepted throughout in the judgment. As per the settled law, a plaintiff has to stand on its own leg. Only when has to stand on its own leg only when the plaintiff discharges initial owner and makes out a case. Ownership shifts to the defendants to disprove plaintiff's case. In the instant case, the respondents have utterly failed to establish circumstances under which the property owned by Joydev was exclusively recorded and mentioned in the name of Ganesh Singh by Exhibit 1. Further, whenever the property Joydev was acquired, my lord, kindly see, they immediately looking at Joydev because he is supporting the respondent one, acting on their behalf. They said like this: Joydev, property of Joydev. What is the question? Exhibit 1 related Ganesh Singh and Ganesh Singh others. My lord, whenever the property of Joydev Singh was acquired by the state, Joydev was already dead. The records of rights are already mutated. Then also they are telling Jaydev or his legal heirs equally. On the counter argument, learned advocate for the advocate on behalf of the respondent submitted the exhibit 2 creates a new title in favor of the respondents, and the appellants have nothing to say in the matter. Learned Senior Judge Harsuda in the entire judgment placed heavy burden on the appellants to establish their case by exonerating the respondents from their initial burden. So what is the case? There is nothing. It is straight case matter. These are the documents were to be entitled. Now they said that because they have proved Joydev's property, so that's why we have shifted the onus on them. The senior judge Harsuda entire judgment placed heavy burden on the appellants to establish their case by exonerating the respondents of their initial burden. It further appears learned court in para 9 of the judgment has taken into consideration the certain extraneous. Yesterday I was telling that certain extraneous matters, Kukia family, etc. That was dealt in the trial court judgments. So certain extraneous materials like allotment of property in the name of Kukia, in the sons of Kukia, by exhibit 2. Now the principal question that remains for the consideration is status of exhibit 2, that is the order dated 17/8/57, passed by Additional Deputy Commissioner, Hirakud Land Organization in Revenue Question of so. It is clear from the said order that this, as a settlement measure, displaced portions of the submersible area of the project, the state proposed an allotment of wasteland at Mauja Kirarama, basing on the report of the Additional Tahsil, 19% named in the allotment statement, which were provisionally allotted to wasteland for the purpose of reclamation only. It is directed that they will complete reclamation within 2 years from the date, failing which they will lose their right under the order, and the land may be given to other persons for reclamation. It is mentioned that they got their names mutated as a tenant, and they got completed. They completed the reclamation. Column number 18, the statement indicates that Ganeshwar Singh was allotted an extent of properties measuring 8 acres at Mauja Kirarama. The respondents have filed copy of letter number so and so regarding exhibit 4 regarding grant of tenancy right in favor of the displaced persons, which speaks the modalities to be observed before the settlement of property. It is further clear that the record during process of settlement field inquiry is made by the concerned appeal. The memorandum of inquiry and copy of the order sheet in DC Patta mutation case number 7/98 has been filed exhibit 5. It was found that by the time of final settlement of property, the original DC permission holder was dead. None were in possession of the suit property. Accordingly, London Additional Tahsildar ordered for settlement of allotted properties in the name of legal heirs of DC Patta holder. Accordingly, order has been published in the name of both parties exhibited. Next page, the next para. It is submitted by the London advocate on behalf of the parties on the appellants that the exhibit 2 cannot be strictly a document of allotment of property DC Patta confirming exclusive title in the name of Ganeshwar Singh. My lord, here let us have a pause. My lord, I have shown the exhibit 4, but the government decides that it is already inquired, re-established, nothing to be worried about, and the DC Patta allottees or legal has to be settled with. Now, here they say it cannot be said to have strictly a document of allotment. Well, next, the said document just a piece of provisional allotment letter. The respondent have failed to produce scrap of paper to show that Ganeshwar Singh has completed the process of reclamation. This is all they said, that in the file that they say that is already done. Field inquiry done. Everything done. It was to settle, it was delayed. That was the fact. Then next, on the other hand, next few lines thereafter, on the other hand, this court has every reason to accept whenever the property owned by the common ancestor, my lord, here again, Jaydev, how, my lord, importing the idea of respondent number 1, my lord. Ancestor Jaydev was acquired for the project. And what is the question of Jaydev? The suit property allotted by the state is to be equally owned by his legal heirs. The learned assent Lakhanpur has rightly taken into consideration, my lord, kindly see, rightly taken into consideration this aspect and finally choose to settle the property in the name of both parties and declare them as rights by the order dated 29/5/2000. My lord, the order already we have, my lord. On the other hand, the learned advocate on behalf of the respondent simply stated, Ganeshwar Singh being the exclusive allotee of the suit property, his legal heirs, the present respondents are exclusive title holders of the same. The submission raised by the learned advocate on behalf of the appellants appears to be more reasonable. Just my lord, kindly see the language of ADJ, my lord, appears to be more reasonable and justified. Now, this is the perversity. Whenever the properties of common ancestor Joydev was acquired for the project, it is not known how Ganeshwar Singh was allotted the suit property exclusively as a settlement measure. I find sufficient force in the submission. My lord, again, another perversity. I find sufficient force in the submission of Ganeshwar being the eldest son of Joydev and Lambardar Gontia must have, my lord, the use of word, my lord, must have allotted the suit property not in his individual capacity, but in the capacity of the eldest member of the family. Can you see the language, man? Here they said that it is reasonable. Their pleadings are we find more reasonable and justified. Here they must have. Now, otherwise, Exhibit 2 cannot be said in a strict sense of allotment and not dissipate or conferring exclusive title in favor of the Ganeshwar over the suit property. Before confirmation of title, sufficient procedures to be followed, and finally the property is to be settled by the confirm and by the concerned tahsildar. The response have failed to produce any document, so Ganeshwar has complied the directions of the authority and reclaimed the property in his individual company. What is the question, my lord? The scheme itself says that it is already re-established. What this coined is re-established after due inquiry by the commissioner, deputy commissioner. So now here again said, my lord, thereafter, the tahsildar failed to produce also. My lord, I must mention that. My lord, kindly see the emotion of the court. I must mention that learned trial court has erroneously laid emphasis on Exhibit 2 by shutting his eyes on the circumstances under which the property was provisionally allotted in favor of Ganeshwar, proceeded to hold that Ganeshwar was the exclusive owner of the suit property. He has also taken into consideration the extraneous materials like allotment property in the name of sons of Kukia. The view of learned trial court therefore not tenable under the law. Now, thereafter, after discussing this partition which was not required at all, this is a straight case. It is in Ganeshwar's name. It will be settled. Here the partition they brought. So that is not, it is not to be looked into at all. What is the question of partition? And the partition, if at all partition is important, then whether this suit land was the part of the subject matter in the partition? No. It was the government land. It was with us. And it was in individual capacity, in the individual name, Ganeshwar. Now, after dealing with some partition, my lord, on the 10 lines, he says, and the last, whenever, when I have perversity again, perverse language, whenever common ancestor of the party Joydev is recorded on the property under Khunti number 1 and 2 by Exhibit A and B, it is not known how Ganeshwar has been declared as the exclusive property under Khunti number 1. Again, the recording of the government, the British records made, also doubt suspected that how he became the exclusive owner. No, but he doesn't speak why Exhibit A, my lord, the sea property of in the name of Joydev, why it is in the name of Joydev alone? He didn't ask. But why in the name of Ganeshwar? It is asked. In my view, again, my lord, in my view, the respondent cannot take advantage of Exhibit 1 to claim exclusive title over the suit property. Further, Exhibit 2 cannot be equated with the recipota, but the same is only a provisional letter of allotment of wasteland in favor of the hostage of the project. Well, I got it, man. Learned trial court basically relied upon the such said document and citing the provisions of Article 230 of Hindu law of Mullah, has observed that suit property is the exclusive property of the respondents. In absence of any clear proof of partition between the parties or their predecessor in interest, it cannot be said that the suit property was exclusively meant for the respondents. It is for the benefit of the entire family. I don't know, I must have understood the way the ADJ had dealt with the case. But in the case, they developed Jaydev as the common ancestor. What is the question of common ancestor? It is the name of Ganeshwar. It is already mutated under Exhibit 1. And Exhibit 2 says that it is allotted to Ganeshwar. What is the question of Jaydev? Now the Tahsildar also did that. And that too, this respondent number 1 has been said that it is the adopted son of Devendra. Devendra has 2 daughters. After death of Devendra, he became the adopted son. Without the knowledge of these 2 daughters and mother, he became the adopted son and became entered into the arrears of this. That my lord yesterday shown in the additional documents. Now, he disbelieved Exhibit 1, Exhibit 2, and the accepted the pleadings of respondent number 1 and others, saying that it is benefit for the entire family. Now, my lord may kindly see the last line of the first. It is for the benefit for the entire family. There is sufficient materials before the court that both parties are in possession over the suit properties. You are satisfied. Now, next parameter. It is contended by the learned advocate on behalf of the appellants that civil court has no jurisdiction to entertain this suit. Suit is barred by law of limitation, Article 58 of the Limitation Act. Admittedly, the appellants have failed to challenge the order of joint recording of the suit properties. And let's see. We failed to challenge the joint recording of the suit properties. Not in time, because they accepted the order, earlier order was 29/5/2000. So 3 years, it will come to, so we filed the appeal in 2003 and suit in 2006. So it is barred by limitation. The learned court did not accept our pleadings of Section 17. When it is fraud has been committed under our rights during 2000, 2003, ignoring our application, appellant's application, I have shown of 1998. Now they say they have not called, they have noticed us. They have not allowed us to appear for spot inquiry. They have not. I was not noticed at all.
Anyway, he holds that it is barred by limitation.
Yes. Thereafter, my lord, the same thing, my lord, after the mass decision below, now they said there is nothing on record that Tahsildar Lakhanpur has done something wrong beyond jurisdiction. The respondents should have challenged the order dated 16/9/2005 passed by sub-collector Jasuda before competent forum instead of approaching civil court. For right title interest of competent forum to have been approached. I find sufficient force that the suit is also barred by the law of limitation. Under Article 58, the Limitation Act, the findings of the learned senior civil judge Jasuda that the respondents have got right title interest is therefore not sustainable and declared joint. Last para. The both parties have the right title interest over the suit property and their position over the same is same confirmed. And before that, Respondent number one has sold out the land from the suit land. Partition, he took 2.80, others 1.6, ours is 1.6, by way of partition. Now he, from that 2.8, he sold away, Annex 2021, my lord, I have already stated, 1 acre sold out. And that too, it is in 2005.
So that's it?
My lord, the other aspects, my lord,
What aspects?
limitation, this thing, or I will reply afterwards. Because the entire case is on perversity of the otherwise after.
Who's appearing? You are appearing.
For respondent number 3 to 9.
2 to?
3 to 9.
3 to 9. Yes. And who else is appearing?
Respondent number 1.
Respondent number 1. So tomorrow you will make your submissions, Mr. Udgata? You also be prepared for tomorrow? Tomorrow, let us, how much time will you take? 30 minutes seems to be a little bit long. So we'll keep it as part two next week and
next week, wait.
Yes.
Next chance.
Hey, Kali, sorry, no, sorry, Kali, I am.
Kali, no, sorry, Pune, Jibo, sir, within the week after.
Next week, you will not be available. All right, that can be considered. All right. किसी लिखे दरकार नहीं खाली पास ओवर फॉर द डे लेकिन ये हो